Good afternoon to our listeners on Parliament Radio 105.5 FM, our viewers on the Parliament channel, and those of you joining us via the World Wide Web on the Parliament's website www.ttparliament.org. In just a few seconds, we'll begin today's sitting of the House of Representatives. There are 2 questions that qualify for oral answer, in addition to 5 urgent questions and 9 questions on the Prime Minister's question time. 1 report is to be presented, the second interim report of the Joint Select Committee on the Whistleblower Protection Bill, and debate is expected on 2 matters today. We take you over to the chamber for the start of the proceedings.
The Honourable Speaker.
We welcome you to the 18th sitting of the House in the first session of the 11th Parliament that takes place on Friday, March 18th, 2016.
Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established amongst us for all generations. Amen. Amin. Namaste.
Oath or affirmation, announcements by the Speaker.
Honourable members, the following members have asked to be excused from today's sitting of the House. The Honourable Nicole Oliver, MP, Member for Labrie. Mr. Edmund Ford, MP, Member for Tunapuna. Dr. Bohindranath Tiwari, MP, Member for Caroni Central. The Honourable Camille Robinson Regis, MP, Member for Aruka Maloney. The Honourable Anthony Garcia, MP, Member for Rima. And Dr. Rudal Munilal, MP, Member for Urupuch East. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers, reports from committees.
The member for San Fernando West.
Madam Speaker, I beg to present the following report. The second interim report of the Joint Select Committee appointed to consider and report on the Whistleblowing Protection Bill 2015.
Prime Minister's questions.
The Leader of the Opposition.
Thank you very much, Madam Speaker. Question 1, could the Honourable Prime Minister give an undertaking to provide to this House with all the documents and legal advice concerning the discontinuance of the case involving Malcolm Jones for the purposes of transparency and public accountability?
Madam Speaker, you understood by public statement that the opposition leader has indicated an intention to file a motion in this House. We welcome that motion, and in such motion, any and all information concerning this matter will be made to the House.
The Leader of the Opposition.
Speaker, question 2 to the Honourable Prime Minister. Can the Prime Minister inform this Honourable House as to the status of the Caribbean Gas Chemical Limited, Mitsubishi Matsui project, in which the National Gas Company has an interest?
Madam Speaker, I'm not clear what Caribbean Gas Chemical Limited, in which the National Gas Company has an interest about. Could the member clarify that, please? I'm not aware that NGC has as a visual petrotrin. There's a petrotrin issue which fits this bill and an NGC bill. What are you talking about?
The project that began in La Brie with reference to the private sector through Mitsubishi and Matsui, and agencies of the government. It may well be petrotrin and or NGC.
Well, if you're referring to the NGC project, that project is under the Mitsubishi project. Yeah. There are discussions taking place at the level of the Energy Subcommittee where there are 2 or 3 very weighty matters which were part of the contractual arrangements, and this government could not have allowed NGC to have entered into any further commitments where the public interests were in such dire jeopardy. Discussions have taken place and are taking place. We have made some considerable progress, and it's the expectation that sometime in the not too distant future a revised position can be available and the project may be allowed to proceed if we come to a conclusion that's acceptable to the government of Trinidad and Tobago.
Thank you, Madam. Thank you, Madam. Through you, thank you, Honourable Prime Minister. Would Prime Minister be able to tell us in broad the general areas of concern that are now going back into further negotiations?
Given the fact that these discussions are taking place, I would not want to do that now. When the matter is concluded, at that stage you may want to refer to them. But very sensitive discussions are taking place now, and it will not be wise to allow that to be put in the public domain before we get an appropriate response from the participants.
Supplementary question.
Thank you, Madam. Thank you again, Honourable Prime Minister. Would the Honourable Prime Minister be able to indicate to us whether the project therefore is at a standstill or whether any work is taking place?
I don't know about the project and work. What I was talking about and what it is the conditions under which a project can go forward. What I do know is that the last government turned the sod for a project on which the agreement as to what the project is likely to be is only now being discussed. And that kind of madness is now being addressed by this government. And since you want to know, let me not go there. After we finish discussing this matter, and I hope we come to a conclusion which is satisfactory, this project, NGC has a 20% interest in it. We expect that we are close to an agreement on discussing the terms of the project. When that is finished, we will report to the country, and the country will understand the level of recklessness that the last government exposed the population.
Supplementary question.
Yes, ma'am. Thank you again. Would the Honourable Prime Minister be able to say when this should be completed, about what time frame he's looking at?
The most I can say is soon. The discussions have been ongoing for a couple of months. We have very good people involved. We have made some progress. We expect some responses from the participants. And if the progress continues along the same trajectory, we expect that in the not too distant future we can conclude this with the public interest protected, with the business interest available to go forward, and we might have a project.
The member for Shogunas, supplementary question. The member for Barataria, stand on.
Prime Minister, could you just indicate who is the chairman of the Energy Subcommittee?
I am.
The member for Shogunas West.
Thank you, Madam Speaker. To the Honourable Prime Minister, has the government received any proposals with respect to the sale of the ArcelorMittal steel plant in Point Pisses?
No, the government has received no such proposals. We've seen things published in the newspapers, but we do not have a proposal in front of us.
Supplemental question.
Thank you, Madam Speaker. The Minister of Finance in the public domain has indicated that he has not ruled out the purchase of the plant.
The minister also said in that same context, in that same sentence, that he is not saying that the government is going to purchase it. And just for clarification, there is no decision by the government to purchase any plant. The minister also said he is meeting with the company on Monday, I think it is? Today. And that is a prerequisite to understanding what the situation is, what the company is talking about. But rest assured, any decision made by this minister or any other minister will put the public interest of Trinidad and Tobago first and foremost.
So, supplemental question.
Thank you, Madam Speaker. To the Prime Minister, can the Prime Minister confirm if indeed the purchase of ArcelorMittal is being considered by the National Tripartite Advisory Council?
No.
Member for Kamuto Mansanilla. Member for Caroni East.
Thank you, Madam Speaker. Question number 4 to the Honorable Prime Minister. Could the Prime Minister state the government's response to Moody's Investors Service placing Trinidad and Tobago's bond ratings on review for downgrade?
The government's response is to remain observant. This is a standard matter which goes on all the time, and to the extent that a rating agency is considering our circumstance and ruling on our situation, this government will not do what the last government did, which is to disregard a rating downgrade, because it is not something that we can be proud of, and it's not something that will help us. It's something that will hurt us, because it allows us only to borrow in a more expensive way and to be seen to be less of an environment in which investments can be made. So we simply have to wait and see what the agency comes up with. But what we will not do is to disregard and poo-poo what a rating agency says about Trinidad and Tobago, like the last government.
Member for Caroni East.
Honorable Prime Minister, in the event that Moody's confirms the downgrading of the investment, could you give to the House and to the Parliament your thinking on the question of foreign borrowing based on the matter being more expensive for foreign borrowing, and how would you see that in relation to local borrowing?
These are speculative positions, and I won't want to be speculative. We'll cross that bridge when we come to it, and we'll treat it in the normal way with respect to how we manage the country's affairs. The downgrade or an upgrade is completely outside of our control, and the one thing we will not do is to hide the circumstances or the report of Moody's.
Member for Caroni East.
Thank you. Would the Honourable Prime Minister indicate whether this government had taken any economic steps to prevent a worsening of the economic situation to widen the downgrade gap?
I am not aware of any economic description which we can relate to of a downgrade gap. I'm not sure what that really means.
Member for Barataria Sanon.
Honourable Prime Minister, just one question. Did FCB remove themselves from Moody's rating system?
If FCB has removed itself from Moody's, I don't have that information.
The member for Kamuto Mansanilla.
Thank you, Madam Speaker. To the Honourable Prime Minister, is the Prime Minister aware of an impending national food shortage? And if so, what is the government's plan to deal with this?
Madam Speaker, I'm pleased to report that the government is not aware of any impending food shortage. As a matter of fact, we are taking steps and making progress in increasing the local food supply, and we're ensure that the population has available and adequate supply of food.
Member for Kamuto Mansanilla.
Thank you, Madam Speaker. Can the Honorable Prime Minister state how and what steps are being made based on your statement?
If you're referring to the actions we're taking, the Ministry of Agriculture is investing a lot of time, effort, and resources into ensuring that more farmers are involved in the process of producing food. We are expanding our rural access roads. We are working on encouraging the population to buy and use local produce, which we are producing more and more of. And we are, in fact, expecting that the lands given out to Caroni workers by this government and previous governments, most of the lands will come into production for the purpose for which they were given, and we expect that that will increase the food supply. We are also producing more seeds to make seed and planting material available to farmers. We are reopening the seed production in Chagaramas, and so on and so on and so on.
Member for Kamucha Mansanilla.
Thank you, Madam Speaker. Honorable Prime Minister, I understand from the Supermarkets Association that there is food enough for 3 months. We are speaking about putting things in place for planting. That may be on 3 months. What are the steps for immediate action of food being on the grocery shelves or on person's table as of now, not in 3 to 6 months?
I want to reiterate, just in case a seed is being planted to create panic and panic buying. The government is not aware of any shortage of food in Trinidad and Tobago.
Member for Caroni East.
Would the Honourable Prime Minister indicate, bearing in mind that a lot of the food items come from abroad, and the dollar being moved from 630 something to 660, and the increase in price of foreign food coming in, what steps are being taken by the government with regard to the cost of the foreign foods, and if there is going to be any measure implemented with regards to the import of foreign food?
The government is hoping and taking steps like encouraging the population in the discerning purchasing to focus more on purchasing local produce, and insofar as imported food is required for the basic basket of foodstuff, that we ensure that there is enough foreign exchange available to the importers of the basic food items. And to the extent that there are other items which are outside of the basket of basic items, we expect that those items will be purchased as and when funding is available, and that the using population will not give preference to foreign purchases as against local produce.
Member for Miaro.
Thank you, Madam Speaker. Could the Honourable Prime Minister state the government's plan to address the precipitous rise in food prices? Thank you.
I would love for the prices to become precipitous. And if you do know, please let us know. We'll join you in that. If you're referring to an acceleration in prices, what we taking steps to ensure that, given the fact that we have an adequate supply of foodstuff, those who import, those who produce, they set the basic price. The government has left out all fresh produce from any taxation. The government has also reduced or removed taxes from the basket of basic foodstuffs, and we are trying to ensure that persons who are engaged in the business of selling food to the population do not break the law. And to the extent that that is happening, the officers of state, we are calling upon them to find and prosecute persons who are profiteering in the supply of food.
Member for St. Augustine.
Thanks, Madam Speaker. Could the Prime Minister, as head of the National Security Council, please indicate the Council's plan to deal with the sharp and unmitigated increase in the murders in Trinidad and Tobago?
Against the background of this question, Madam Speaker, I want to assure you that shutting down the security and listening systems, cancelling the offshore patrol vessel contract, not appointing a commissioner of police for 2 years, those kinds of things, that approach has come to an end. And this encouragement to discuss This encouragement to discuss the business of the National Security Council in public will not happen under this government.
Member for Barataria Sanwan.
Prime Minister, could you indicate if you will be revisiting the plan to use the Harris digital system for information for all protective services rather than the analog system being used now that is pretty slow?
I am not in a position to give you that commitment because the terms that you're using are terms that are not entirely descriptive of the action that we are taking.
Member for Caroni East.
Thank you, Madam Speaker. Question number 8 to the Honorable Prime Minister. Could the Prime Minister state how the government intends to address the current foreign exchange shortage in the context of the continuing fall in foreign exchange reserves?
Madam Speaker, the management of the foreign exchange is the responsibility of the central bank, which intervenes in the market from time to time based on a number of factors, including demand, supply, and economic factors. And the circumstances will be addressed as they prevail and with respect to our ability to supply foreign exchange as earned.
Caroni East.
Bearing in mind what the Honorable Prime Minister indicated, are you aware that the national population and individuals are experiencing severe hardship and difficulties in accessing any foreign exchange at times, whether 200, 500 US, to deal with matters that are urgent, paying for students' education abroad and for paying for medical issues abroad as well? Could the Honorable Prime Minister indicate what his government can do, bearing in mind also, as he indicated, the central bank role in this? But the government has a fiscal policy as well, which should be able to ameliorate some of the hardships.
Madam Speaker, the member is confusing fiscal and monetary policy. The shortage of foreign exchange has very little to do with fiscal policy. And in managing the monetary arrangements and the flow of foreign exchange to the banks, the central bank manages it in the best way with respect to supply and demand, supplying foreign exchange to the commercial banks. We are aware that there are difficulties being experienced, but those difficulties have their root in the country's loss of significant inflows of foreign exchange. There is a reduction in the country's earning of foreign exchange. And of course, the big difficulty that we're facing is ensuring that what the central bank provides to the commercial banks are allocated in a way that is fair and reasonable. That's right. And that's where the challenge really lies.
Started a long time ago.
Caroni East.
Bearing in mind that the Honorable Minister of Finance had discussions with the central bank governor in the past, and this one, would he be undertaking any conversations with the central bank governor, which he said that he can do, to ameliorate the existing situation, which you indicated you're quite aware of, the hardships existing? Would you recommend that the Honorable Minister of Finance have further conversation with the central bank governor on this matter?
When I made a while ago about managing the demand and the supply and the economic factors include the Minister of Finance staying in contact with and working with the central bank on this matter. It does not exclude the ongoing conversations between the Minister of Finance and the central bank.
The member for Chaguanas West.
Thank you, Madam Speaker. To the Honorable Prime Minister, is the Prime Minister aware of the gas master plan that was completed by the former administration?
I'm not aware of a gas master plan that was completed by the last administration. But if you're referring to the gas master plan which was presented to the government of Trinidad and Tobago, this government, yes, I'm aware of it.
Member for Chaguanas West.
Thank you, Madam Speaker. Could the Prime Minister indicate the key initiatives of that gas master plan to the House?
In the fullness of time, that plan would be We're expecting that that plan will be presented to the Energy Committee of this House, the Energy Subcommittee of this House, the Joint Select Committee. At the moment, the plan, having been presented to the government not too long ago, has been the subject of considerable cabinet review. It has been before the Energy Subcommittee of the Cabinet, and in the not too distant future, we expect that we have the plan brought to the House's subcommittee.
Member for Chaguanas West.
Thank you, Madam Speaker. The Honourable Prime Minister indicates that in the fullness of time, could he be much more specific than that?
Not full is the time.
We are hoping to do it in the not too distant future. At the moment, the plan, there are some aspects of the plan which are attracting the attention of the Energy Committee, which requires that the plan remain there for a little longer, but maybe in a month or two.
Urgent questions?
The member for Barataria Sanwan.
Thank you, Madam Speaker. To the Minister of Health, given the Zika outbreak, which has now claimed another victim, could the Minister state when the Insect Vector Control Division of the Ministry of Health will attend to all schools throughout Trinidad and Tobago?
Thank you, Madam Speaker, for the opportunity to answer this very important question. I will give a comprehensive report on all spraying activities, inclusive of schools. Madam Speaker, to date, the number of schools treated are 103. The treatment of schools will continue unabated until the Easter vacation, where we hope to have all schools treated. Madam Speaker, for the period of January, 64,192 homes were sprayed. For February, 61,541. And for March to date, 31,824, giving you a total of homes treated so far of 157,557. The ministry has also engaged insect vector in the spraying of public spaces, for instance, licensing office, community centers, and so on. For the period up until for March only, when we started this program, 32 public spaces have been sprayed. In addition to spraying activities, Madam Speaker, the fight against Zika also has a legislative angle, and I can report to this Honourable House through you that yesterday Cabinet agreed to amend Regulation 27 of the Yellow Fever regulations to increase the fine for homeowners who do not keep their properties in a proper condition, overgrown bushes, derelict vehicles. The fine, which was previously $500, which proved not to be a deterrent, has been agreed by Cabinet to be increased to $3,500. These are some of the measures that we are taking with the concurrent jail term of 6 months. So these are some of the actions being taken.
For Karen Keys.
Would the Honourable Minister indicate, bearing in mind that there are over 800 schools in the country, and for the last 3 months you have sprayed about 100 plus, as you indicated, what steps would you be taking to expedite the spraying of the 700, bearing in mind that you said by Easter, which is about 3 weeks, 3 weeks again, within the next 3 weeks, how do you intend to spray these 700 schools that are outstanding?
And that's what I said, we will continue. Over the period, we are also engaging the services of local government, which I announced on January 29th when we declared a public health emergency, that all agencies, inclusive of local government, will be on board, so that give us more boots on the ground, more equipment, and so on. So we are confident that over the Easter and into the following term, we can address this. And as you know, we have been spraying even through Christmas vacation and so on.
Member for Barataria Sanwan.
Thank you, Madam Speaker. Supplemental, Minister of Health. After your spraying is completed, you must have a continuity of action.
Yes.
Will the Minister consider revisiting the plan to employ 500 people already interviewed at the Ministry of Health to assist the perifocal operators in determining breeding grounds and continuation of breeding grounds throughout the system for the Aedes aegypti?
Thank you, Madam Speaker. Madam Speaker, the Ministry of Health will consider all avenues open to it, inclusive of what you have said. We are also considering engaging civil society in the fight against this via public education, and I will speak about this in about 2 weeks again. So we're looking at all available avenues to fight this.
Member for Caroni East.
Thank you, Madam Speaker. Question to the Honorable Minister of Finance. Given that registered money transfer agencies have advertised their inability to provide forex to citizens, what steps has the government taken to ensure that citizens seeking to purchase U.S. currency to conduct business are able to comfortably source said foreign currency?
Thank you, Madam Speaker. In the first instance, money transfer agencies such as Western Union and MoneyGram are not normally used to transact business, but it is necessary to give some understanding of what these companies are and what they do. Money transfer companies usually have local currency denominated bank accounts in the various jurisdictions in which they conduct business. For example, when they accept Trinidad dollars from clients requesting that US dollars be transferred to the United States, the United States counterparty makes the payment to the beneficiary in the United States. The counterparty would similarly facilitate the transfer of funds from the United States to Trinidad and Tobago. At some predetermined interval, weekly or daily, the two branches, the two counterparties, the branch in Trinidad and the branch in the United States or other country, settle what is owed on a net basis. If ultimately, say MoneyGram or Western Union, Trinidad and Tobago owes MoneyGram United States, the former would need to source US dollars from local dealers to settle their foreign currency debt. And as indicated earlier, the central bank is charged with the responsibility of managing the supply of foreign exchange in Trinidad and Tobago.
I'm still yet to get the answer to the question, but perhaps I might be able to receive it based on this additional the supplemental question. The agencies are experiencing difficulties and inability to get the foreign exchange. So therefore, what is the Minister of Finance doing to help these people who go to these foreign agencies to get their funding?
Thank you, Madam Speaker. I think it is necessary to advise the honourable member of the different types of foreign exchange dealers in Trinidad and Tobago. You have cambios, you have money transfer agencies like Western Union and MoneyGram, and then you have the commercial banks. Money transfer agencies operate on a reciprocal basis, so that if Trinidad and Tobago citizens residing abroad or citizens residing abroad send foreign currency to Trinidad, it goes into the bank account here in Trinidad. And if Trinidadians send money abroad, it has to be converted into the foreign currency. If there's an imbalance between the amount of remittances coming out of the United States, for example, and the amount of Trinidad dollars going out, whether it is to China or Colombia, because we've noticed some large outflows to those particular countries, then the money transfer agencies will have to source money from the commercial banking sector, and they will go into the queue like any other customer.
Member for Caroni East.
My understanding of the queues at the commercial banks are inordinately long and perilous for citizens, and they are unable to get anything whatsoever.
Member.
So what are you doing to assist the ordinary person through the commercial banks to get funding for their day-to-day activities that are so critical to their existence and their family's existence?
Thank you, Madam Speaker. I think these questions being asked by the honourable member betray a fundamental understanding of the management of foreign exchange in Trinidad and Tobago. It's the foreign exchange supply is managed by the Central Bank of Trinidad and Tobago, not by the government of Trinidad and Tobago. It's managed by the Central Bank. And that is why from time to time, the Central Bank will intervene in the market
and inject foreign exchange into the market to top up the supply that comes from the natural conversion of foreign exchange by companies in Trinidad and Tobago doing business where they earn foreign exchange. So what the central bank does is it tops up the shortfall in foreign exchange, and it manages the whole thing based on demand and supply and economic factors. I don't know what more I could tell the honourable member.
These are urgent questions. Only 2 supplementals are allowed. Member for Point of Pear.
Thank you, Madam Speaker. To the Acting Minister of Energy, the Honourable Senator, could the Minister confirm or provide clarity concerning the emerging concerns that the government is likely to dispose of the infrastructural assets in the National Gas Company?
Thank you, Madam Speaker. Madam Speaker, the government is not aware of any emerging concerns with respect to this matter. But having said that, I guess this emanated from a newspaper article a couple of weeks ago, which indicated the disposal or pending disposal of some of NGC's assets. To bring clarity to the situation, Madam Speaker, the NGC has received proposals from Repsol for the acquisition of NGC's offshore compressor facilities, which supply gas to Repsol crude oil operations for gas lift purposes. This gas doesn't come onto the open market. This is what they call internal use of gas. It is recycled into the well for gas lift purposes. The proposal is currently under review. And I want to state categorically here to this Parliament that no decision has been taken on this matter.
Member for Chaguanas West.
Thank you, Madam Speaker. To the Minister of National Security, given the recent upsurge in violent crime, including murder against prison officers, what plans does the Minister intend to implement with immediacy on this matter?
Thank you, Madam Speaker. Madam Speaker, plans follow strategy, strategy follow policy. The policy of the government is based on a whole of government approach to treat with crime. The strategy is based on 5 pillars: prediction, deterrence, prevention, and detection, Madam Speaker. Those 5 areas are being strengthened by the agencies of Ministry of National Security. With respect to the prison officers, Madam Speaker, I have held meetings with the Prison Officers Association and the Commissioner of Prisons, but the very plans, the very measures that we are adopting would not be placed in the public domain because it would in itself compromise the very lives of the prison officers, Madam Speaker.
Member for Couva South.
Thank you, Madam Speaker. To the Minister of Labour and Enterprise Development, could the Minister give an update on what urgent steps have been arrived at by the Cabinet to treat with the ArcelorMittal steel plant labour issue?
Thank you very much, Madam Speaker. Madam Speaker, this situation regarding the retrenchment of workers in Trinidad and Tobago continues to present us with many, many challenges. The government of Trinidad and Tobago remains very concerned over this situation because the current economic realities underscored the government of Trinidad and Tobago's need to treat with the negative impacts of retrenchment on the labor market and the effect on the lives and livelihood of the workers and their respective families. Madam Speaker, the Ministry of Labour and Small Enterprise Development has developed a 10-point plan on retrenchment titled Empowering Retrenched Workers, Reintegration into Decent Worker, Turning Adversity into Opportunity. This plan was developed based on discussions and feedback from key government ministries such as the Ministry of Trade and Industry, the Ministry of Social Development, the Ministry of Health, the Ministry of Education, and other key stakeholders. It also entailed, Madam Madam Speaker, engaging members of the business community, the Trinidad and Tobago Manufacturers Association, financial institutions such as the Credit Union League, the Bankers Association of Trinidad and Tobago, the National Insurance Board, Trinidad and Tobago Mortgage Finance Company. These are financial institutions, Madam Speaker, who would have direct control over these workers and their need to repay their loans and mortgages. I would want to inform this Honorable House, Madam Speaker, and in particular the Member of Parliament for Couva North, that South.
Honorable Minister, I'm sorry, your speaking time has expired. Member for Couva South.
Thank you, Madam Chair. The Minister of Labour and Enterprise Development continues to refer to a 10-point plan. Could the Minister advise this House as to the specifics of this 10-point plan?
Madam Speaker, indeed, I will, once time permit. Madam Speaker, I have just come from my ministry where we have launched the National Retrenchment Register, which would enable us at the ministry to capture those workers who were retrenched, in particular those workers who would not fit within the conformity of the law. The law requires an employer who is retrenching 5 or more workers to report that retrenchment to the ministry. But once an employer is retrenching less than 5 workers, that falls under the radar. So this retrenchment register, Madam Speaker, is to enable us at the ministry to capture those workers who fall under the radar and thereby put us in a better position to understand exactly how many workers in Trinidad and Tobago have been retrenched over the period of time the Member of Parliament seeks to get. The other aspects of this 10-point plan, Madam Speaker, is the development of a marketing campaign to solicit new jobs for retrenched workers and to facilitate jobs and skills. The third aspect of it requires us to engage in training and retraining collaboration with the National Training Agency, with the National Energy Skills Center, because many of these workers are highly skilled. They have the experience, but Madam Speaker, they do not have the certification. For example, we have discovered in the Ministry of Education, the schools, there is a shortage of technical vocational instructors. Our intention is to retrain these specialized retrenched workers, certify them, so they can now convert into a new career path, for example, as technical vocational instructors in the schools under the Ministry of Education.
Time has expired. Member for Siparia.
Thank you, Madam. Honourable Minister, would you kindly tell us how many workers who, out of the 8,000 or so workers fired or retrenched, how many have benefited from this fantastic plan you have been describing?
Madam Speaker, to the Member of Parliament, to Siparia, firstly, I am not aware that 8,000 workers have been retrenched, as you have articulated. However,
we please have a bit of silence, please. Continue.
Thank you, Madam Speaker. To the member to Siparia, the plan that is unfolding, this plan was developed in response to the retrenchment, particularly the massive retrenchment that took place last week, Friday. In less than 1 week, Member for Parliament for Siparia, the Ministry of Labour and Small Enterprise Development, with its hard-working public officers, sat down and developed this plan that is being implemented as we speak. I just came from launching the National Register.
I would like to hear the contribution of the Minister, please. Please proceed, Minister of Labour.
Madam Speaker, I wish I was part of the government. Perhaps in 2015 I could have developed this plan. But nonetheless, Madam Speaker, the massive retrenchment that is taking place in this country, I wish to remind this House, Madam Speaker, began last week, Friday, and it is snowballing, and as a consequence, this is a plan that has been developed to be implemented and is being implemented as I speak.
On notice, questions for oral answer.
The member for Prince's Town.
Thank you, Madam Speaker. And the member for Prince's Town is here, but in his absence from the House at this point, number 69 to the Minister of Rural Development and Local Government. Thank you, Madam Speaker. Madam Speaker, the lack of proper office accommodation is suffered by all regional corporations, with the exception of Chaguanas Borough Corporation, which has a spanking new administration building, proudly built by the People's National Movement. In 2011, Madam Speaker, Cabinet agreed that the Ministry of Local Government enter into a contract with the Rural Development Company, the RDC, for the construction and outfitting of the proposed new Princestown Regional Corporation Administrative Building. Cabinet also agreed that the RDC borrow $115 million for the construction and outfitting of the building, and that the loan be guaranteed by the government. 4 years elapsed after this Cabinet approval, and the terms of the loan were not finalized until August 20th, 2015, just 2 weeks before the September 7, 2015 general election. However, the conditions precedent to the disbursement of the loan was not met by the RDC, and the loan offer subsequently lapsed. In any event, Madam Speaker, the contract for the construction of the Princestown Regional Corporation Administrative Complex could not have been awarded. The award of the contract is pending resolution of outstanding fees to Jasper, Bogle and Associates for design and consultancy service from UDCOT, the initial project managers. JBA, that's Jasper, Bogle and Associates, is also owed outstanding fees for design and consultancy services for the Rima Borough Corporation and the Gomartin Regional Corporation administrative complexes, which were not paid by the previous administration. Accordingly, the Minister of Rural Development and Local Government met with JBA in January of 2016, and the issue of its outstanding payment is currently under active review. Finally, Madam Speaker, the Ministry of Rural Development and Local Government is currently in a reform process to restructure and decentralize the local government system, as you may all be aware. Accordingly, the Ministry will be reviewing the construction of administrative buildings in all corporations in the context of the new mandate which will be given to municipal corporations. A priority listing will then be determined. Therefore, a decision on the commencement of the construction of the Princestown Regional Corporation Administrative Complex will be subject to this review process and obviously, Madam Speaker, to the availability of funds. Could the Honourable Minister indicate when this review process will be completed?
Well, the review process will be subject to the consultation, and what is the final position with the local government reform exercise, and that really we're looking at the latter part of this year.
The member for Prince's Town.
Thank you, Madam Speaker. Question number 71 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, I crave your leave and seek a deferral for 1 week to provide a full detailed answer to this question.
Leave is granted.
Requests for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Barataria Sanwan.
Thank you, Madam Speaker. Madam Speaker, in accordance with Standing Order 17 of the House of Representatives, I hereby seek your leave to move the adjournment of the House for the purpose of discussing a definite matter of urgent public importance, namely, the denial of jobs for returning medical graduates who have completed their internships and need jobs in the public sector in order to maintain their provisional registration by the Medical Board. This matter is definite since the regional health authorities have taken a decision to deny jobs to a large number of returning medical graduates who have finished their internship, and by refusing these graduates, their hopes of full registration will not be realized. The matter is urgent since there is a shortage of medical professionals in the public health institution of Trinidad and Tobago. Therefore, the lives of hundreds of patients who may have benefited from the services of these trained and qualified returning medical graduates are now at risk due to such a decision. And the matter is of public importance since it has the ability to prevent a large number of returning medical graduates who have completed their internship from becoming registered and hence from practicing medicine in Trinidad and Tobago.
Honorable members, I am not satisfied that this matter qualifies under the standing order. I advise that the member pursue this matter under Standing Order 16. Member for Couva South.
Thank you, Madam Speaker. In accordance with provisions of Standing Order 17, I hereby seek your leave to move the adjournment of the House for the purpose of raising the following definite matter of urgent public importance: the failure of the government to effectively deal with the rising tide of dismissal, termination, and retrenchment of workers. The matter is definite because since the 8th of September 2015 to date, conservative figures in the public domain reveals that over 3,500 workers in both the private and public sector have been retrenched, dismissed, or terminated. The matter is urgent because notwithstanding the obvious suffering and hardship now meted out to thousands of workers and their families, the government has not tangibly and positively dealt with their plight. The matter of public importance because the loss of employment is widespread across both the public and private sector, and it has significant negative impact on the socio-economic stability of Trinidad and Tobago.
Honorable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursue this matter under Standing Order 16.
Statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister.
The member for San Fernando West.
Madam Speaker, having regard to the second interim report of the Joint Select Committee appointed to consider and report on the Whistleblower Protection Bill 2015, I beg to move that the committee be allowed an extension of 7 weeks in order to complete its work and submit a final report by April 29, 2016.
Honorable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the Whistleblower Protection Bill 2015 be allowed an extension of 7 weeks in order to complete its work and submit a final report by April 29, 2016. All in favor say aye.
Aye.
Any against? I think the ayes have it.
Public business, government business, bills, second reading.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Strategic Services Agency Act, Chapter 1506, to expand the functions of the Strategic Services Agency be now read a second time. Madam Speaker, genuine democracy is impossible and freedom of political opinion and communication a chimera unless citizens are afforded freedom from fear of criminality and crime. I make that introductory statement because it is appropriate in considering the legitimate aim of this legislation, which is a marker which one must consider as a legislator in considering the proportionality of any law that comes before the House of Representatives or the Senate. That we put into context how pointed the aim on this occasion in this bill is. Madam Speaker, we have before us a bill which is a rather short bill. It proposes in 5 short sections to amend 3 particular clauses, sections 3 of the Parent Act, section 6 of the Parent Act, section 9 of the Parent Act. The Parent Act is, of course, Madam Speaker, Chapter 1506 of the Laws of Trinidad and Tobago. Standing behind these 3 substantive clauses, there is a proclamation clause as well included, and the short title. Seems rather simple, but Madam Speaker, again, in commitment of the undertaking to provide a transparent mechanism for consideration of matters before the House, I'm very pleased to announce that we have passed out, not only together with Bill Essentials, but the Attorney General's Office has passed out a marked up version of the amendments included in the substantive clauses of the parent legislation. And that's important because when one seeks to amend legislation, laws ought to be appreciated in the full context of the law that one is amending. Madam Speaker, this law, the Strategic Services Amendment Bill, as we propose now, amending the Parent Act, Chapter 1506, as we propose now, interarticulates with at least 11 pieces of law directly. They are the Constitution of the Republic of Trinidad and Tobago, the Proceeds of Crime Act, Chapter 1127, the Trafficking in Persons Act, Chapter 1210, the Interception of Communications Act, Chapter 1508, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Dangerous Drugs Act, Chapter 1125, the Anti-Terrorism Act, Chapter 1207, the Firearms Act, Chapter 1601, the Police Service Act, Chapter 1501, the Defense Act, Chapter 1401, and proposed legislation which relates to the Computer Misuse Act and which is to be expanded. Madam Speaker, I've reflected upon these provisions because the genesis of the interarticulating laws must be considered in the legitimate aim. The SSA Act, the Parent Act, was a creature born in 1995. Specifically, it was introduced into the Parliament then on the 11th of September 1995 by the Minister of National Security, John Eckstein, in those days. And it was born to address an international obligation which started in 1961. Then 1971, there was another recurrence of it. Then 1981, and then we went to 1995. Specifically, Madam Speaker, in 1995, it was noted by Minister Eckstein then that we were rooted as far back then to the 1961 United Nations Single Convention on Narcotic Drugs, Article 35. In 1988, Trinidad and Tobago became a signatory to the Geneva Convention on the prohibition of illegal drugs, basically, and psychotropic substances. And there was an international obligation then that we take steps to coordinate the fight against drugs. Why? Drugs then prevalent, as perhaps more prevalent today than ever, was the root structure around which criminality was built. Around that root structure flourished then, as seems to flourish now, gang activity, firearms and ammunition on an illegal sense, trafficking in humans, trafficking in children, trafficking of narcotics, the worst form of criminality to be seen in terms of the prejudices visited upon the citizens of our country. And then, without complaint, especially as it relates to constitutionality, because I listened to public utterances of the now opposition, which I intend to address frontally in this presentation, speaking to there being a need for some form of constitutional majority. But in 1995, headed then by Bastio Pandey, leader of the opposition, Ramesh Lawrence Maharaj, well-capable senior counsel now, several members then, not a squeak was made on constitutionality. And I'd be very interested to hear the arguments today, which we will address frontally. But coming out of the structure then, in 14 simple clauses of the parent law, Madam Speaker, we saw, and allow me to pull it up, in the Strategic Services Agency Act, we saw a very interesting formula birthed. And the formula that was introduced then is the one which we seek to amend today. The parent law, which we must consider as a whole, provided for an architecture in 14 sections, including the reference to regulations, of an establishment of an agency, a director, staff of the agency, functionality of the agency, the provision, importantly, for secondment, the provision for disclosure of information, funds and how monies were to be applied to support this agency and operationalize it. Very importantly, the accounts and audit functions. The financial year end was fixed, the principal office and annual report. And I want to stress that in providing for accounts and audit, funds, financial year and audit by way of consideration through Parliament of presentation of annual reports, we birthed then in 1995 something which stood on the laws of Trinidad and Tobago, which was proportionate. It allowed for a director of the SSA to report to a member of the executive, the Minister of National Security, to engage in coordinated surveillance activity, coordinated receipt of information, dissemination of information to international partners, the creation of strategies to assist an entity defined as services, which I'll come to in a moment, under the supervision of the executive, but balanced by way of very important measure, balanced by way of the fact that the persons who received this information were of a particular category of persons. First of all, they were public officers under the Police Service Act. Secondly, public officers under the Public Service Commission. And coming with the public service entities, those two, the police service and the public service, of course, are the constitutional safeguards for the Police Service Commission, which operates under Chapter 9 of the Constitution in sections 121 onward, and the Public Service Commission. But, Madam Speaker, in having that one class of personality, that is public servants, be they police, be they public officers, including customs, including immigration, all as public servants who are regulated by the constitutional safeguards of balance. Alongside with that was the use of contract officers. And contract officers, again, had to be under supervision by oath of secrecy, etc. And the balance then created in that law, which was confined only in those days to surveillance of drug activities, complex issues, be they regional, local, or international, what we had then was a balance of proportionality for a legitimate aim, the aim being to take control and eradicate the scourge caused by transnational shipment of drugs. In that legitimate aim and in providing the services, police, customs, Trinidad and Tobago Defense Force, immigration, we had a balance where contract officers were also to be regulated, because this agency has an obligation to report its financial management, the monies received, etc., to the Parliament of Trinidad and Tobago through a very important constitutional entity rooted as the Auditor General of Trinidad and Tobago. What happened in the period 1995 come forward? Several aspects of operationality went to work. And Trinidad and Tobago, Madam Speaker, had in operation several entities conducting surveillance. There was interception of communication. We saw in 2010, in a very dramatic display, the presentation of the Interception of Communications Act in 2010. But for years, starting from 1962 onward, under successive administrations, be they PNM, NAR, UNC, what we saw was the implementation of surveillance in this country. Specifically, intelligence agencies with entities having an intelligence role included and still include Customs and Excise Enforcement and Operations Unit, Defense Force Intelligence Unit, Financial Intelligence Unit, Financial Intelligence Branch, a division of the TTPS, Integrated Threat Assessment Center, the Ministry of Foreign and CARICOM Affairs, National Coastal Radar Surveillance Center, the Anti-Kidnapping Unit, the Crime and Gang Intelligence Unit, the Criminal Investigation Division, the Homicide Bureau, the Cybercrime Unit, Special Branch, Fraud Squad, Organized Crime and Narcotics and Firearms Bureau, Prison Service Intelligence Unit, the Counter-Trafficking Unit, the Immigration Investigation Section. All of these entities had surveillance issues. Surveillance, of course, includes both operation by persons on the ground, listening, conducting inquiries, and also there was interception of communication. And by way of proportionality in this particular bill, we again have a very material and important assistance provided by the interception of communication legislation. Specifically, members would know that the Interception of Communication Act in Section 6 makes all intercepts of any form of communication, be it visual, be it audio, be it video, whatever type it may be, it makes it unlawful unless one has the authorization of a judicial warrant, and also if it is in the interest of national security as prescribed in the law. The caveat for national security surveillance is that it cannot be used in terms of evidence, and then there is destruction of evidence. But I'm sure my learned friends opposite will have no complaint with that, because they had the privilege of passing that legislation with the full support of the opposition in 2010. Full special majority support. Now, I've taken the time to traverse these issues, Madam Speaker, because it falls into the bill today. I have, in summary, so far demonstrated that there is a whole host and history behind this law, beginning in 1961, taking us through 1995, taking us forward for the operationality of the SSA. I have demonstrated that there is proportionality by having the executive power balanced off by the Auditor General, the Parliament of Trinidad and Tobago, by the judicial supervision of any interception of communication, and I've shown that it's been rooted in the issue of the management of the scourge of criminality associated with drug crimes, drug trafficking. And what we seek to do here today is to take the definition of dangerous drug, or the limitation to drug-related matters, and to broaden it in a very significant way, with all of those safeguards. I hear the words again in crosstalk from someone that can't yet rise. I hope he will speak in this debate. But anyway, I will say that Couva South I'm talking about, constant muttering. But anyway, Madam Speaker, what I will say is that the criminality that we hope to address is to be found in the broadened recommendation today of the use of the expression serious crime and crime. In the bill, Madam Speaker, we will find, by way of proposed amendment to Section 2 of the Act, the Parent Act, that we use the expression serious crime. And basically, and quite simply, everywhere where we have used the expression drug-related offense or trafficking in narcotics, what we have done is to substitute, quite simply put, the expression serious crime. And what is a serious crime as proposed? Offenses related to homicide, treason, terrorist acts, terrorist financing, hijacking, kidnapping, trafficking in persons, trafficking in children, because they are two separate categories, gangs, illicit trafficking in narcotics, drugs, psychotropic substances, precursor chemicals, dangerous drugs, corruption, money laundering, smuggling, terrorist acts, terrorist financing, arms and ammunition, chemical, biological, nuclear weapons, weapons of mass destruction, cybercrime, transnational crime, and any offense which carries a penalty of not less than 5 years imprisonment. Crime prevention means...
Would you kindly give way?
Sure.
I note your reading of Clause 2 of the bill, which sets out the definition for serious crimes, and I certainly agree with the list that you have given. I would be happy if you would kindly give us the rationale for including crimes which attract a penalty of 5 years, because the ones you've given before would give us the really serious crimes, the homicides, the money laundering or whatever, murder. The serious crimes, for example, can you tell us which ones are being targeted when you say the 5 years?
Sure.
Because there are some offenses there that I'm not sure your definition says serious crimes include, and you put this. Now you're including those with the 5 year to the 10 year. And I'm asking kindly for the rationale for that.
I thank the Leader of the Opposition for the inquiry, which is a very good one. First of all, the answer is rooted in bringing the legislation in equal measure to the Proceeds of Crime Act, specifically where the formula is used. It's also used in the anti-terrorism legislation. Insofar as that fines measure there, it's specifically intended to take care of the evolving needs of law, and that law shall always speak. It's true that the use of the word include means that the class can be expanded, and that the use of the expression any offense with 5 years is an expansive all-sweeping clause. However, it was specifically intended to take care of the fact that surveillance and intelligence centrality that we're now proposing, or rather just expanding because it exists, would allow for investigative intelligence work to be managed on a broad sense. And if I could say this, insofar as one may allege that there could be a mischief in too broad a category, let me deal with that. Insofar as one could allege that, it is to be found in the legitimacy of the aim of the type of offense that we're dealing with. First of all, the current law that we're dealing with narcotics, etc., that current law, if we looked at the marked up version of the legislation that we circulated, and it was specifically for that purpose, the current law includes specifically drug trafficking had the same meaning assigned to it as the expression in the Dangerous Drugs Act. And when we looked at the Dangerous Drugs Act, you would see that the law spoke in broader senses. But because this law allowed for a surveillance of anything to deal with dangerous drugs, that allowed for all things touching and concerning dangerous drugs to flow. And that's important because it is a very important feature of this law to recognize that the purpose of the SSA is being preserved exactly as it was. That purpose is intelligence only. The operationality is never a feature of this law. There will never be an occasion contemplated in this law, hence the reason why it was passed originally with simple majority legislation, for an operational arm to go to work, because the intelligence gathering is passed off for action by the Trinidad and Tobago Police Service, by the agencies in customs, by immigration, by international partners through international mutual legal assistance. And because that prescription is there, one cannot fall afoul of the prescriptions as offered by Lord Diplock in the very famous case of R.V. Hines, or taken forward into DPA versus Cooper, or Cooper versus the DPA, both Privy Council decisions, or be it Thomas and Batiste, again a Diplock dicta, which says that you should never allow the executive to create, in essence, a private army for the suppression of democracy. That prescription cannot apply here because of the division of functions, intelligence versus operations being handed over. But Madam Speaker, let's deal with the mischief that exists right now in Trinidad and Tobago. The mischief right now as anchored in our fourth round mutual evaluation experience, is that we have been told as a nation we need to improve our particular coordination of intelligence. That's a fact. One cannot go into the descriptions because of confidentiality issues in clause-by-clause analysis of what is referred to as the MIVAL or Mutual Evaluation Report and the recommendations there. But suffice it to say, the recommendation has been that we need to do better with the sharing of information and coordination of information. Secondly, the report of the Commission of Inquiry appointed to inquire into events surrounding the attempted coup d'etat of 27 July 1990 made very specific recommendations as to revisiting the national security architecture, observations and recommendations. Specifically, at pages 220 to 243 of that report, laid by the last government in Parliament, we saw strong recommendation for a host of improvement in national security architecture, specifically with respect to the broadening and coordination of national intelligence. And why? Report after report, be it the report that came from the intelligence agencies by Major General Cameron Ross in 2009, or be it the Commission of Inquiry into the attempted coup in 1990, they all speak to the difficulties that a country experiences in having entities which conduct surveillance activities not speaking to each other. And, pardon? Yes, thank you, Honourable Leader of the Opposition, for recommendation that there are several other reports as well. But the problem, the mischief we're dealing with, is that there has been a siloing of information. The left hand doesn't speak to the right hand. Now, this is not something that my learned colleagues opposite would not know about. In fact, in looking at material for this debate, after we had presented the bill, I came across quite a bit of work that was found in the Ministry of the Attorney General, in the LRC department in particular, and that work pointed out to there being information on specifically the problems with siloing. And I'd just like to reflect upon that for a moment. The last government specifically had a proposal for the amendment of the SSA Act. The last government specifically had a proposal for the treatment of the National Operations Center. The last government specifically had a revised structure for the SSA. Now, what am I speaking about? The mischief that currently exists without this all-encompassing tie-up now is that the architecture for law enforcement in Trinidad and Tobago is siloed, agencies that don't speak to each other, but the Ministry of National Security and the National Security Council have billions of dollars of assets that are unregulated, unsupervised, and in respect of which there is no transparency. The National Security Council has in its fold right now the National Operations Center. The last government specifically saw the birth of the National Operations Center by minute number 1005, dated March 12, 2014, which spoke specifically in its structuring to the acknowledgement that there was a need to provide and that the NOC would provide and manage secure information sharing, intelligence with requisite protocols, a facility for joint operations, a facility to control data center that would store information, security division to be a primary conduit to receive and disseminate information, security and safety related matters. All of these matters, including the facilitation of intelligence fusion, critical information support, tactical response to support law enforcement, that's what exists without this law. Because the NOC has that structure birthed by the last government. What we propose in this is to take that structure of the NOC, take the now defunct, because it has expired, National Security Training Agency, born on the back of the National Intelligence Agency recommendations, take those things and to park them under the careful supervision of an SSA structure which allows for parliamentary scrutiny, which allows for the Auditor General to come and look at it, which allows for reports to be put on the table of the Parliament, which allows for reports to be debated. That is to make a move into transparency from a move where there was darkness before. Now, I don't make complaint like was offered by the last opposition in the period, especially in 2008. We heard a lot in 2008 about an alleged unconstitutionality of the Special Anti-Crime Unit of Trinidad and Tobago. We heard song and dance about it. The fact is, the Special Anti-Crime Unit operated quite lawfully, firstly under Section 75(1) of the Constitution of the Republic of Trinidad and Tobago, which gives Cabinet the control and authority for the affairs of government. Secondly, under the Defence Act, by the appointment of specialist units that could work in joint task force together with the police under the Police Service Act and Regulations 2006 as saved by Regulation 10's operationality in the new law. And with that constitutionality parked, we heard a lot of complaint. Fact, there was never a legal case brought in the courts of Trinidad and Tobago, but after the implementation of SORT, and we saw statistical improvement in detection and conviction, taking us up to 49% detection and conviction rates when SORT was in full functionality. It was shut down, and then this opposition, then in government, spoke to a new structure and architecture, the National Operations Center. The Gibran report suggested a National Operations Center. It suggested a training academy. But we then saw that opposition, this opposition, then in government, enter into joint action forces and the NOC, with the powers that I just told you in a minute, of the National Security Council, with tactical boots on the ground, with intelligence gathering facilities. We saw joint army patrols together with the police under what? Under Section 75 of the Constitution, under the Police Service Regulations, under the Defence Act, under the very things which gave SORT its power. The last government operated fully. But did you hear then opposition, now government complain? Not once. Why? Because we are responsible and we recognize that if something was intended to provide resources for the benefit of Trinidad and Tobago, that we would support it. And that's why as an opposition then, we supported 97% of the laws coming out of the last government for the benefit of the people of Trinidad and Tobago. Madam Speaker, what else? I can name them all. I did the statistics. Where are we? Coming out of the CFATF fourth round mutual evaluation, there's a very important factor. We in Trinidad and Tobago are obliged, Madam Speaker, to operationalize international treaty obligations. And specifically, our treaty obligations, if I can find the list here, include, and permit me just the opportunity to find that, specifically, our treaty obligations include a host of laws which we have not dealt with. Let me deal with the most recent. UN Security Council Resolution 2178 on foreign terrorist fighters. Specifically, Madam Speaker, the list of legislation dealing with International Convention for Suppression of Financing of Terrorism, 1999. Inter-American Convention Against Terrorism, 2002. Mutual Legal Assistance Treaties, Extradition Treaties, Convention on Offenses on Board Aircraft, 1963. Convention Suppression of Unlawful Seizure of Aircraft, 1970. Convention Suppression of Unlawful Acts Against Safety of Civil Aviation, 71. Convention on Prevention and Punishment of Crimes internationally, 1973. International Convention Against Taking of Hostages, 79. Convention Against Nuclear Material, 1980. Protocol Against Acts of Violence, Airports, 1998. Convention Suppression of Acts, Maritime, 1988. Protocol for Suppression of Unlawful Acts, Platforms, 1988. Making of Plastic Explosives, 1999, 1991. Convention for Suppression of Terrorist Bombings 1997, International Convention Suppression of Financing of Terrorism 1999, Protocol to Prevent Suppress Trafficking in Persons, especially women and children, November 2000. But all of these disparate international obligations have not been met. For instance, foreign terrorist fighters, weapons of mass destruction, explosives, money laundering as identified by the CFATF obligations which we share in the FATF 40 plus recommendations. None of these have been coordinated in a centralized entity to give us, by way of purchase of tax-paying dollars with scrutiny provided to that, a centralized, efficient operation. And why do I stress the point of efficiency? Madam Speaker, the negative reflection which we received as a country in relation to our fourth round mutual evaluation, which put us in a follow-up process, was very specific. The condemnation of Trinidad and Tobago was that we are not being efficient in our laws. We heard the head of Transparency International the other day say, what's missing in this jurisdiction is the FBF, the fry the big fish. People talk about money laundering everywhere. I have raised publicly already that the Ministry of the Attorney General will begin next week, in fact, a public interaction and campaign on the work that we are doing and have now purchased after 6 months of hard work on the prisons, on the criminal justice reform, on declogging the systems, on specifically dealing with money laundering and civil asset forfeiture, which we hope the opposition will support. But in dealing with that, in looking for frying the big fish, what are the statistics in Trinidad and Tobago? We have from the FIU their report, which says in their 2015 report laid in this Parliament that we have had over $3,665,199,126, $3.7 billion in suspicious transaction reports or suspicious activity reports in the period 2011 to 2015. What are the statistics? In Trinidad and Tobago, we have had 68 seizures. Amount detained, 4.2 million TT dollars, 121,000 US dollars. Amount forfeited, a whopping total of 250,000 TT dollars. Money laundering, we have 10 offenses before the court. 10. Suspicious transaction reports disaggregated, 2011, 303, 2012, 258, 2013, 554, 2014, 617, 2015, 609. Is it any different for the other form of serious offenses? Murder, rape. Let's look at those figures. Murders, 2010, 485, 2011, 354, 2012, 383, 2013, 408, 2014, 403, 2015, 410, steady climb upward. Detection and conviction rates going down. 2016, 99 to date. Each one unacceptable. Somebody said, tell us about 2009. Extremely high. I don't have the figure. Let's assume it was higher than every year in the 5 years. Let's assume that. What was the detection and conviction rate? 49% with respect to gang-related homicides. Where did it go to under the last government? 3%. 3%. Trinidad and Tobago Police Service statistics as disaggregated source of information. But, Madam Speaker, what was the nuclear bomb dropped in terms of operational efficiency? A state of emergency. We saw it in the figures. We saw in 2012 a drop down to 383. I could tell you, as Attorney General and Minister of Legal Affairs, millions of dollars in false imprisonment, in malicious prosecution, nearly 7,000 people detained, released. Wash.
He gave us the evidence, yeah.
You want evidence, Naparima?
Yeah.
Facts from the DPP's office. facts through the judiciary of Trinidad and Tobago. But it's okay to chuckle and laugh because you know who's paying for it? Taxpayers. Taxpayers who today are receiving complaints causing panic opposite by members opposite, where people are asking, where is the purchase for my tax-paying dollars? What have you done with it? And that is why the SSA in relation to money laundering is important. The SSA in relation to anti-terrorism is important. The SSA in relation to detection and intelligence on gang-related activity and homicides is important. Because woundings and shooting, 2013, 542. 2014, 558. 2015, 600. Today we hear questions about the rapid escalation of crime. Rapid escalation, 2010, 2011, 2012, 2013, 14. Yes, year on year our citizens seem to become more violent. But what do? Do we stand up in a glorious blame game? This side versus that side? Or I'm anticipating, you know, there was a press conference held by the leader of the opposition, no less a character, honorable member that she is for Siparia. And she's saying, that's what you're doing. I must listen to utterances in the public domain and answer them on the floor of the parliament, because here I speak through you, Madam Speaker, to the listening population who's paying attention. And when we hear condemnation, that this is draconian legislation, fact, last government contemplated it. Fact, last government purchased billions of dollars worth of operational and tactical assets and parked them under the NOC without any form of transparency or supervision. That is executive danger zone. Today, we seek to put transparency on that. Today, we seek to introduce that to the cleansing light of joint select committees. I watched today the public inquiry into the DPP's division, the Legal Aid and Authority, into the Attorney General's office. It's a pity that as a member of the executive I couldn't step forward to say what we as the executive are doing about it, because the rules prescribe against that. But what I will say is that we have taken a step to settle the system. And if you want this system to work, yes, we need architecture like the SSA bill amendment proposed today, but we need to make sure we have people to do the job. That's why we have taken the task in the Ministry of the Attorney General and Legal Affairs to analyze what the cost of expanding the public service will be, in keeping with the Prime Minister's statement in opposition now as government policy, to make sure that the scourge of contract labor is treated with. So people have job security, that the public service can have decency and respect in their approach, because you must operationalize the law. You can't just pass law. You can't leave it in a vacuum for 5 years. We can't on the one hand have emboldened the national security apparatus without any transparency and then potentially come here today and complain you're creating more power for the executive. That can't be the case, most respectfully, Madam Speaker, because we have an obligation as a nation to depoliticize the issue of the economy, the issue of crime, the issue of health, the issue of education in particular. And I say that, I'm hearing Siparia, every time you stand up you say that, I'll say it over and over and over again, because that is what we did when we were in opposition. And we assisted the last government right down the line, including supporting the first budget. So, Madam Speaker, where are we today? Is there a legitimate aim before the Parliament? I dare say that there is one. There is an issue repeated over and over again of a siloing issue of intelligence management and positioning. Secondly, is there a legitimate aim in taking control of national security apparatus, putting it in an agency which has supervision of the Parliament and the Auditor General under the Constitution of Trinidad and Tobago? Yes. Is there a legitimate aim in tackling trafficking in persons, trafficking in children? Is there a legitimate aim in dealing with money laundering when we have only 10 matters before the court? Where is the big fish?
Billions.
$3.7 billion in STRs, suspicious transaction reports, and SARs, suspicious activity reports, and 10 people before the courts. As a nation, in the last 5 years, we've forfeited the whopping sum of $250,000 TT in the context of $3.7 billion. Is that being efficient? Let's look at the systemic problems. Let's agree that it's time to do something about it. Let us stand up as a nation and dedust the problems, which is why next week we are going to open the doors on the issue in the prisons, in the AGLA, Attorney General and Legal Affairs Office, and start that conversation of telling Trinidad and Tobago how many people are incarcerated, how long are they incarcerated, what the cost of incarceration is, what the throughput through the system is, how the criminal justice system must be managed, so that flowing from that as a springboard, one can consider the appropriate amendments that have lay in analysis paralysis for far too long with respect to trial by jury, with respect to declogging the criminal system from a remand and pre-conviction detention systemic issue, the problems of surveillance in the prison systems, the problems of supporting our hard-working members of the protective services, including the prisons, the problem of making sure that we deal with the capacity and human power issues in the DPP's office. Isn't it high time that we really considered disaggregating the civil prosecution from criminal prosecution and moving to the statement where you have proper attorneys at law representing you by competence and not necessarily by choice? I'm saying these are conversations to be had. And I'm hearing quite remarkably from Siparia that I'm not talking on the bill. This is the bill. Section 2 of the bill, Clause 2, speaks to serious crime. Serious crime includes all of that. And if you can't appreciate that most respectfully, what are we doing? This is the bill. This is a serious matter. It sat for 5 years and then years prior that without moving where it should be going. If you look at the Commission of Inquiry's report into the 1990 attempted coup, chapter and verse of what we should have done, could have done, perhaps should have done, but didn't do. Well, today we are doing that. Today we are delivering the solutions that are required for Trinidad and Tobago. Madam Speaker, in broadening the operation of the functions of the SSA, we are specifically putting into gear simply a mechanism to coordinate all of the services of intelligence gathering. Time for the left hand to know what the right hand is doing. Time for that to be balanced in the transparent light of proportionate balance, where the executive does not have an unchecked power through an agency which has existed for the period 1995 to come to date. But, Madam Speaker, specifically, we must as a nation consider how we approach the whole of government approach to crime. You hear the Honorable Minister of National Security speak time and time again that this must be a whole of government approach. And in dealing with the SSA from a whole of government approach perspective, it is material, therefore, that we add into this public procurement laws, we add campaign finance reform, we add local government reform, we add revenue management, as we have done on our agenda, and as the Minister of Finance has been complimented insofar as the IMF has said that the government is moving in the right direction, and responsibly so, to tackle hard issues. Because, Madam Speaker, you have to have a certain sense of rectitude and courage to embrace the tough issues, you know. You don't embrace tough issues by making sure that the IMF doesn't come in 2015 to do its Article 4 consultation. You have to face the music, Madam Speaker. Madam Speaker.
20 seconds. Honourable member, his speaking time has expired.
Madam Speaker, I beg simply to move this bill, noble as it is, with legitimate aim, for consideration of all members, and I look forward to the support of those opposite. I beg to move.
Honorable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Strategic Agencies Agency Act, Chapter 1506, to expand the functions of the Strategic Services Agency, be now read a second time. Leader of the Opposition.
Thank you, Madam. Madam Speaker, the Honourable Attorney General, in his usual very eloquent fashion, has attempted to give us some of the history of this, the parent legislation, and of course to show, or to give an expose as to the rationale behind this particular amending bill. Contrary to his view that the opposition will not act and will not work where it is in the best interest of the people of Trinidad and Tobago, I want to make it very clear. We said this at the start when we came into opposition, and I want to repeat it, that where we believe that you're bringing policy measures and legislative measures that will work in the interests of the people of Trinidad and Tobago, we will support those measures. But I think we do have a duty to raise our concerns with respect to certain provisions that may be contained in the legislation. That is indeed the role of the loyal opposition of the Republic of Trinidad and Tobago, that those voices that have put us here, that we have a duty to record concerns that may have been raised with us by stakeholders and by constituents and others. So whilst I want to, excuse me, whilst I want to, I'm sorry, Madam Speaker. There are so many viruses going about, you know. I know the minister is spraying vigorously everywhere. Yes, it was at about 3 a.m. in the morning. I heard the sprayer passing on the main road, and I wondered, if you'll permit me, on the main road, and I said, you know what, I mean, great, because there was less traffic. I was wide awake on the computer. And, but you may want to consider something else, which I'll be minded if you wish in the tea break we can talk about, to make it more effective than just this thing zooming along the main road. Sure? And I'm saying, Madam Speaker, that we have no difficulty in principle with the provisions in this bill, with the intent and purpose of the bill. In fact, as the Attorney General has pointed out, we had been hard at work for many years on trying to centralize intelligence in the country. And what we had proposed, and the reports the honourable members referred to, would show that. The Gibran report, the Russ report, several of those reports over the years, was to have what was called an NIA, a National Intelligence Agency. The government is seeking to do it through the SSA, and again, as I say, in principle, we have no objection to that being done. And so, in terms of the purpose of the bill, in terms of the overall intent of the bill, we support it. Now we may turn to specific concerns that we do have, and to ask you to consider those concerns. Not just with a view to stand up and say, and I totally agree, there must be areas where we must depoliticize issues that touch and concern the benefit of the people of Trinidad and Tobago. And this is one instance where the fight against crime is not your fight alone. It is not our fight alone. Now, you say it all the time. It is a fight of all people of Trinidad and Tobago. And today, I ask you, Honourable Attorney General, I will raise some of the concerns, but they are myriad, they're numerous. And given the way that this interlocks with other pieces of legislation, and you mentioned them, you mentioned several pieces of legislation that are all interwoven into this, will be impacted by this, that you may well want to consider, sir. With due respect, a joint select committee, we are prepared to work with you on it. Should you not agree to that? Should you not agree to it, we will propose certain amendments for your consideration. But I do believe, given all the interlocking pieces, you mentioned over 10 pieces of legislation, that a little more time is needed for proper work to be done to analyze what this bill is about. I mentioned and I asked you, when it comes to clause 2 of the bill, I had asked you to give us a rationale as to why you are now including offences attracting a maximum of 5 years under the definition of serious crimes in section 2 of the bill. And really, whilst it sounded really nice and eloquent in what you were saying, I didn't really get what was the real rationale for putting these in. I asked you, tell us at least an example of one offence that would be included with this. Now you're putting serious crimes in the category of 5 years. All the others we have no problem with. I have absolutely no problem. I think anybody here will have any problems with the inclusion of serious crimes to have homicide, treason, terrorist acts, terrorist financing, kidnapping, hijacking, trafficking in persons, trafficking in children, gangs, illicit trafficking in narcotic drugs, etc., dangerous drugs, corruption, money laundering, smuggling, terrorist acts, terrorist financing, arms and ammunition, chemical, biological and nuclear weapons and weapons of mass destruction, cybercrime, transnational crime. No difficulty whatsoever. But I still want some clarity as to why we've gone to any offence which carries a penalty of not less than 5 years. And I asked you for an example. Now, I can think of an example from the research we've done. Sedition is now included. And whilst it may well be that that is something that government will want to keep a handle on, at the same time, it is an area that can be open for abuse. Once it is that someone may not like the words of a person, we would have to look at, for example, because when the Honorable General, you did say, through you, Madam, that when it was passed in 1995, the Parent Act, it did not require a constitutional majority and none was asked for. But you see, in 1995, you didn't have the Interception of Communications Act 2010. Now, with that Interception of Communications Act 2010, other powers have been given to the director of the SSA. And if we are looking where social media has now gone viral, as we say, and I know there have been concerns about social media from your side, from all sides, as to what extent bringing into the dragnet now these on the 5-year max load on, the max for sedition is 5 years. And you know, this is something that we have to be very careful, because we're looking at Facebook. You're looking at closed groups on the Facebook that you will now be giving power for tapping and tracking into. Now, I have no difficulty sedition in terms of open communication, an open Facebook account. But if I am talking to the Honourable Member Port District North St. Anne's West on a closed Facebook page, what are we talking about? That is like sitting in my living room or his living room, though I hope I will never have to sit there. I hope I will never be sitting there. That we are sitting one-on-one in anybody's living room having a conversation. Can that conversation now then be taken up as being now to be hacked into, to be spied upon, to go into issues of sedition? I'm asking for us to look at that again. I do know it is an issue that of great concern. You know, in this country, how many charges have been brought for sedition? To the best of my knowledge, to the best of only 2. Well, Port District North is away. Only 2. In all the years of our independent nation. And so why are we, one was, yeah, and there was another one, might have been with the coup, the first coup attempt. So 2 out of, the hundreds, not hundreds, well, 40 or 50 years of independent Trinidad and Tobago, and even under the common law, I am not aware of any being brought, but certainly for independent Trinidad and Tobago. Can the proportionality which the Honourable Attorney General spoke about, can that balance of proportionality, be sufficient to bring in the sedition issue when only 2 matters have arisen and therefore does not pose the kind of a serious threat that the Honourable AG is speaking of? Do we really want to do that? And I'm saying, given the fact now that we are looking at the powers under the Interception Act, but the Interception of Communications Act also gives us pause for cause, because under that act, yes, one will go to the court to get a warrant, as was already mentioned, and also you can intercept without getting the warrant with respect to other matters. But that act specifically, the Interception Act specifically, talks about offences 10 years with a penalty of 10 years. So that within the Interception Act, the SSA director is listed as an authorized officer to authorize interception of communications, whatever they may be. And in that act, I ask you to look what kinds of offences they're speaking about. And it has to do with offences attracting over a max of 10 years. 10 years or more, sorry. 10 years or more. Again, I have a concern with this 5-year limit, unless you can show us the rationale. Now, I think there is another offense that may well be one that attracts a max of 5 years or has a 5-year maximum penalty. It may be simple larceny. And simple larceny, I know we have a serious difficulty for statistics when we were there with larceny of motor vehicles. That has been on the increase, and it's a serious matter. It's a serious matter. So where I can see that being placed on the here, I am still saying, I ask you, pause for a course when it comes with respect to sedition matters. I go further in terms of concerns that we have. When we look at the consolidated section 6 now, the track changes which you have so proudly indicated you shared with us, for which we thank you. The track changes in the consolidated track version. In that, I have so much paper on my desk, but in the tracking, if we look at section 6, what you're now doing is to place power again now in the hands of the SSA for a large number of things. It is not, as you said, a simple act with a few clauses, but it is so expansive in scope and expansive in intent. And section 6 of the Act, which I'm still looking for, the Parent Act, section 6 of the Parent Act lists those. I can look at it in the... one moment, please, Madam Speaker. I'm sure I have it. The tracking. Yeah, here it is. It's on your desk instead of mine. The track changes. It's mine, but it's spilled over into the... Yeah, well, I don't have juniors anymore. I am the junior. Section 6, the main functions. What we are now doing, whereas, as you've said, the agency had the power to deal with all these drug-related matters, you now give them powers as follows for what you have now called serious crimes. You have given them power to centralize information, 6(1)(a). Powers with respect to these serious crimes, as you call them. You're giving them powers to develop strategic intelligence and make recommendations, again, in relation to this expanded list of serious crimes. Prepare crime prevention strategies and stimulate action towards and monitor the implementation of the agreed strategies, again, with respect to this wide range of offenses. Advise on policy formation, disseminate information, provide intelligence and analytical support, assist in identifying sophisticated criminal activity, help law enforcement effort by identifying links, and provide strategic intelligence to assist and promote effective and efficient use of operational resources, identify new trends, and provide a nucleus of specialist intelligence personnel. All fair and fine with this expanded range of issues. And because of how wide this is now phrased, I say we have no difficulty with it. We need to have some checks and balances. And I come back to what I see as being important for those checks and balances. And again, when you raise the issue of constitutionality, I do agree that you are not giving operational power, day-to-day operations for law enforcement to the SSA. And therefore, on that basis, it does not require the special majority. As in 1995, with the Parent Act, you didn't need, because you gave really a centralizing of intelligence to that one agency with only the limited drug-related matters. You're now expanding that still as an intelligence gathering. So the issue of constitutionality, Honorable AG, does not arise from that expansion. It arises from the lack of the checks and balances given the expansion of the offences. Given now, we have to look carefully now at the role of the minister. We have to look carefully now, and of course place checks and balances. We have to look carefully now at the manner in which the director is appointed, because now you're given such wide powers, and then you have intercept powers under the Interception Act. So if you're expanding it in this way, we have to look at the manner in which such a director may or may not be appointed. We'll have to look at as well, and I'll come back to each of those with a little more detail. We will have to look at the financing of this agency. We will have to look at the org structure. What are we proposing? This is going to be a massive organization now. The Honorable Attorney General pointed out the fact that there were units at the moment already doing intelligence gathering, and named about 8 or 10 of them. Different units already in the police service doing intelligence gathering, cybercrime, terrorists, the terrorist, anti-terrorist unit, etc., etc., etc. Is it that now all of this is now being subsumed under this superpower that will be the new revised SSA? How much more staff are we talking about now to do all these functions? If it was a specialized matter relating to intelligence on drug and drug interdiction and so on, now you're giving about 20, 30 other very strong, important areas in fighting crime. What kind of staff structure we are looking at? How are they to be hired? At the moment, the SSA is a civilian authority, Madam Speaker. A civilian without the checks and balances, that are given to police when they're operating, in terms of, police must act on reasonable suspicion, they must act in hot pursuit, they have certain powers and so on. We do not have those kinds of checks and balances. When it comes to the appointment with the director, again, what are the checks and balances? And then finally, we would want to look at the oversight requirements. Yes, the present law speaks to a parliamentary report, an annual report, with respect to auditing and with respect to just an annual report being laid in the Parliament. Well, that's it, they're laid in the Parliament, or should be laid in the Parliament. But is that sufficient oversight, now given the wide range of powers that we are giving to the SSA? And taking into account what I mentioned before, the inclusion of intercept powers by the director or officers authorized by him under the Intercept Act to intercept communications. In other countries, you will see where intelligence agencies have such wide powers, they do have two kinds of oversight. They have executive oversight, so they have executive committees set up for that independent oversight, and then they have legislative or parliamentary oversight proceedings. So the work of such an agency could definitely be brought forward. I have given a sort of a synopsis of the main areas of concern. I'll spend a few moments. As I say, I'm willing to work with you all. We are, with more detail to these issues. Let me point out some of the areas where I feel that we may fall afoul of the Constitution, not on the operational issues. In this now, we are speaking about the establishment of a database. I think it is in your last clause in the bill, the establishment of a database. Now, second to last, the penultimate clause. We are speaking about the establishment of a database now, not just for these drug-related persons, again, no, but for all these serious crimes, including the sedition, which I mentioned, and so on. And then it is very vague when it talks about maintaining databases of persons involved in serious crimes. So I have two problems there. One, with the maintaining of this database for this wide expanse of offenses, and secondly, with the ambiguity of the clause persons involved in serious crimes. And I'll come in a moment to a little more about that. This clause has implications for issues relating to personal information and privacy rights under the Data Protection Act. That's another act, AG, on which it has impacted as well. The Data Protection Act, Chapter 2204, deals with the protection of a person's right to privacy. But we also know our Constitution deals with privacy rights in the Bill of Rights sections, which has, if not an analog in the human rights bills, human rights acts of the European Union, not an analog, but definitely has many provisions in paramateria with those found in the European Human Rights Bill. And you would see again, which I'll share with you, that person's right to privacy is infringed where databases are maintained. And I can cite you several cases. I'm sorry? You're familiar with the case. Have you been taking them into account? You did not mention the Data Protection Act when you spoke earlier, so we'll be happy to hear you deal with that. Now, the Data Protection Act, as I said, gives us provisions for general privacy principles applicable to all persons who handle, who store or process personal information belonging to another person. For example, the purpose for which personal information is collected shall be identified by the organization before or at the time of collection. Is that going to apply here, where you're now maintaining a database of persons involved in serious offenses, crimes, serious crimes? Is that, which one takes precedent? The Data Protection Act of these privacy provisions, or this act where you give these powers now to the SSC. The collection, DPA also deals with the collection of personal information shall be legally undertaken and be limited to what is necessary in accordance with the purpose identified by the organization. Personal information shall only be retained for as long as it is necessary for the purpose collected and shall, of course, not be disclosed for other purposes. So how long will these databases be maintained? Personal information of any person, as you've called them, involved in crime. For how long will these be maintained? What will be the process for destruction of such records and so on? Where is that in the bill? Can you point us on to see consideration? Organizations shall, no, but that is only with intercept provisions. But you see, your database will not only have intercept information. That's the thing, you do not really say what the database will contain. What is a database that you are going to have for persons involved in crime, in serious crime? What will it contain? I think I raised that point already. What is it? By whom will it be held? Who will be the custodian of the database? What will be the principles governing the use of it? And then when we come to the disposal of such databases that are being kept. In fact, there was one of the cases, you seem to be familiar with them, there was one case in the, again in the European Union, which had to do with that very matter of where information contained in a database from way back when was being used, and the court ruled that it was in breach of the human rights provisions, similar, as I said, in paramateria, to our own human rights provisions in our Constitution. So we have those cases to look at. Now, the DPA also says personal information shall be retained. Organizations shall accept where otherwise provided by written law. Disclosure at the request of the individual. Now, you are collecting information on persons involved in a database. Does it contain information about the honorable member for St. Joseph? Would he know? How would he know? How can an individual know whether you are on a database? Where there might be correct or incorrect information? Will an individual have any kinds of rights to have a hearing before they are flagged in some database that may be sent all over the world? You are persona non grata for things that may be inaccurate. We saw a case recently with an inspector of police, I believe, where he was set up by some other persons, and the man has now retired. Years later, police officer, inspector, now retired, and the court held that he was set up, you know, and what had happened. Do you remember the name of the case?
Yeah, Harold Phillips and Haridat Marad.
Harold Phillip and Haridat Marad. So, you know, there's... Yeah, in the High Court last week or this week, judgment. So all I'm saying, whichever government is there, we must have the checks and balances to deal with abuse, to prevent abuse. And knowing that once the potential for abuse exists, and we do not have those checks and balances, then it will happen. What is Murphy's Law? What will happen will happen. So we must legislate, not just for today, and not just for what may well be the integrity and the honor of the member for San Fernando West, but it must be for whoever, whichever government, whenever and wherever. We legislate not for today, we legislate for tomorrow and the day and the week thereafter. And I mention again, the database personal information, which is requested to be disclosed outside of Trinidad and Tobago, shall be regulated on comparable safeguards to those under this Act, shall exist in a corresponding jurisdiction receiving that information. Again, here you have this matter in a database. The individual doesn't know whether it's St. Joseph or Port of Spain or San Fernando West, that this is there. Some foreign entity, some other jurisdiction requests it. Yep. You have had no input to say, look, this is a lie, it is not true. How do we deal with that? And then when it is requested, because part of this SSA, the remit is to cooperate with international agencies and so on. How do we deal with that issue?
Happening to the Islamic community already.
Happening to the Islamic community.
Yeah. Bona fide, good people in the cup.
Coming back to the issue of the maintenance of a database. And the issue of the public body SSA disposing of all personal information as control or custody has to be done in accordance with some kind of regulations. And whether those regulations could be regulations made under the remit of this act by the minister, regulations to deal with disposal. So the storage, custody, and disposal, if you would not want to put it in the main act, it can be done by subsidiary legislation by way of regulations. We have seen, for example, that there are no guidelines to govern and to regulate the maintenance of the database of persons involved in serious crimes in accordance with the provisions of the same Data Protection Act. So where is it here? How are we going to deal with it? As such, there are procedural and administrative safeguards and security measures for collection, processing, storage, retention, access, disclosure, and disposal of a person's sensitive personal information in accordance with general privacy principles under our Constitution and under the Data Protection Act. There is no description of the form, type, and or source of information that this proposed database will be based on. So we are left to speculate whether this database will consist, for example, would it be inclusive of or exclusive of biographical data, biometric characteristics, fingerprints, DNA samples, blood types, school records, employment records, criminal records, medical records, financial records, phone records, computer records, electronically recorded messages and images, CCTV footage. What exactly you will be authorized to keep and collect and store in this database? There is also no description of the level of authority or authorization in terms of access control mechanism for the maintenance of the very said database. And so when we look at the cases, as I said before, it is clear that the provision being made in the amending bill for the maintenance of the database is deficient in many respects and will need to be relooked to provide adequate safeguards for prevention against abuse for the citizens of Trinidad and Tobago. And it could be any one of you, I don't know if you recall that in 2010 when we brought the Interception Act.
Sitting ministers?
Yes, the sitting ministers of the then government were on the list of persons being President, the Chief Justice, the trade unions, parliamentarians, sitting ministers of the then government were all on the list of persons being wiretapped. Media personnel too. Yeah, and that's another cause for concern. With respect to the media personnel, they have interactions. They have what is called privileged information, not to disclose their sources, where it is they get information. So where one media house, for example, recently wrote several stories were written about a cash transaction involving a particular minister. And they would not disclose who was their source. Would any closed group, as I say, information being shared, private conversation, could then implicate such a media house by revealing the source of their information? So I'm saying, Honorable Attorney General, the intent and purport is great in principle. We do have these other concerns. We come now to the appointment of the director. 5 minutes? Well, time goes really fast. Thank you. Yeah, I hear you. The appointment of the director. 2 minutes? 2 minutes original time. May I indicate now, I will be, with your leave, take the extra time, please.
You are entitled to do so.
Thank you.
Continue, Honorable Members.
Thank you, Honorable Madam Speaker. 2 issues I would like to raise in the time. As I said, we are willing for further discussions. The appointment of a director. Now, when the director had only just to deal with the drug interdiction matters, that was done, as I say, on the basis of a United Nations draft that was used on our international commitments. Fine. On the model, the UN model. Now we have, as I said, an expanded rule, a really massive rule. Should we not, and we could propose that amendment, in the same way that the Commissioner of Police, for example, the appointment of a Commissioner of Police, because this person is now given so much more, whether we should consider a similar kind of order made for selection and criteria, the process, selection process and criteria. As the Act now stands, the director is appointed by the President. Honorable Madam Speaker, we well know that means appointed by the Cabinet. And so you will have the political directorate appointing a director. So this is a selection process. Is that appropriate given today's scenario and the wide-ranging remit that is now given to the SSA? We have had cause for concern before, and we always said we do not trust you. And no one, we say, should trust you. We should make sure that we put it into the legislation to prevent the abuse. Even the Police Complaints Authority Director is appointed with the advice of the Prime Minister and the Leader of the Opposition. But I will go further, given this very wide remit we now have.
Sanctions.
Huh?
Criminal sanctions.
Yes, and of course criminal sanctions that could apply, or penalties. That we do a similar kind of order, and it could be put in here very simply, that the Director General, the Director of the SSA be appointed in accordance with an order made under this Act by the Minister, which will set out the process, the selection process, and secondly, set out the criteria. Should we have, with this massive amount of powers now, a Director General who has no experience, no any qualification in intelligence gathering, intelligence keeping, or anything to do with intelligence? Surely that cannot be right. And I cast no aspersions on the present Director of the SSA. But when we are doing all of this, which I agree we should do, let's do it right. And we should do it right. So I'm suggesting an amendment to put a process and a selection process order and a criteria order. What qualifications? I know in the report that was given to us from the various units, they had recommended the kinds of qualifications we would like to see such a person have. I think the Gibran report or maybe the Rots report, they had included such things as a master's in business administration, other things with some experience, if not actual qualification, in intelligence gathering and the whole, everything, the whole scenario dealing with intelligence. I mean, if you put you cannot give, you cannot put a civil engineer, I'm not sure, a civil engineer. I'm sorry, we cannot put a civil engineer with this massive portfolio.
We didn't want to say Rishmi, but...
Sure, you can say Rishmi. Rishmi was a tremendous mistake. Look, which I apologize for, and which we corrected in the shortest possible time. And so, we apologize. Today we are here, we are probably paying for that too. And you were there. So do not let the same thing happen to you. Do not let the same happen to you. And so I'm saying, given the expanded role of the... Very limited role. It was a very limited role. It's just drug-related matters. Given this expanded role, I'm suggesting that you put criteria and process, selection process in place. That's with the appointment of the director. Much time, please. The appointment of the director. What about the appointment of staff? What kind of staffing are we now?
3:47.
Yeah. 5 minutes. 5 minutes, please. 12. 12. Thank you.
12 minutes.
Yeah, I'm trying to ascertain because I really would like to get a few points in. Yeah, we're looking at staffing now generally. Now, the government has already placed the National Training Agency under the SSA. The government has already placed the National Operations Center under the NSA. And I'm told, and perhaps you can confirm or deny, I am told that there are at the moment still serious difficulties in merging all these various units together. It's a lot of staffing coming from all over. How they are to be hired, how they are to be fired, what will be the terms, who will set these things? The staff that is now coming in, will it be the director? How is that to be done? Because you're looking at a massive, now bringing enough staff, and maybe some of the workers who have lost jobs all over can be brought in, because you're going to have to hire, to do all of this, you will have to hire a lot more staff. We would be very happy to share with us an org structure for this new, expanded and revised SSA. And in what manner are persons to be appointed? How are they to be appointed? Will it be by a transparent process or not? What, as you said, depoliticized issue now. Whatever mistakes made by a previous government, incarnation of your government or mine, let's put that away and let's try to get it done, get us to do it right. I stand here, I could go back and blame game too, you know. I don't want to do that today. This is too important. And you have said it, and I thank you for that commitment. And let us really try to make that happen. And as long as we don't have Diego Martin Northeast, a civil engineer. Oh, he's a great civil engineer, except when walls collapse, but he's a great civil engineer. Back to you, through Madam Speaker, through you. We are talking about nothing, sir, nothing. The appointment of the director, but I'm talking about other staffing. How is that to be done? Share with us how you envisage it. And will you set a timetable for implementation? Because I'm seeing this as a massive exercise to send all these over to the SSA to get all the staff put in place. And then the issue of funding arises. Is it your intention, the government's intention, to come in the midterm review? And I'm not sure the midterm review is a bill we'll be looking at or whether it's a statement that will be shared with the government. So it's a bill. You don't know. You still don't know. Okay. I would expect it will be a bill that would come with revised allocations and so on. And is it your intention, therefore, to put estimates of expenditure for this revised and expanded SSA? Because surely the budget that is already there will not be able to take on the kind of staff and the expanded role that you now envisage. Because, for example, in 2015, the revised estimates for, the actual estimates for 2014, so that is before the expansion and so on, was $80,000. 80 million, 267, 80 million. Revised estimates 2015, which is gone, was 100 million. But your estimates in the 2016 estimates presented here in the Parliament, it is the same 100 million. Does that 100 million, it seems to me, does not. Does it take up this new and improved and increased and revised and expanded role of the Strategic Services Agency? So where is it funded to come from? So we deal with expenditure issues, we deal with the appointments of the director and other staff. And just one other aspect before I close in the time left. The issue of oversight, the oversight. Now, I mentioned to you that in other jurisdictions, you know, you do have agencies such as this. I think in the UK you have MI15, MI16, MI6, MI5. Okay, in the US you would have CIA and many others which we don't even know about. They're all there, but they do have serious oversight functions, and they have it at their what will be the equivalent of our parliamentary oversight. So you have special committees that deal with national security oversight. And therefore, I would like to see included in this bill amendments that would bring parliamentary oversight, and not simply just as we have a parliamentary committee, but to look at the legislation, the Canadian legislation, the UK legislation, and the US legislation and elsewhere, that we can find oversight legislatively, parliamentary oversight. Yeah, well, my colleagues are saying foresight and not hindsight, but for oversight. I'm looking at oversight, quite frankly. The other kind of oversight has to do, as you well know, in these other jurisdictions, with executive oversight. In some cases, you have committees outside of the Parliament, you have tribunals and so on, that will be monitoring and evaluating the work to see that there is not the kind of abuse that we will all not want to happen. So we want to see that kind of oversight function. At the moment, the tabling of an annual report in Parliament is certainly not, in my respectful view, oversight. The tabling of an auditor's report is certainly not the kind of oversight, given the expanded role. And now, given what I've just said to you, the fact that we cannot look at it, and you did not, sir, with due respect, AG, you cannot look at it in isolation as just the SSA, but we must remember it is married to the Interception of Communications Act, where there are tremendous powers now given to the director of the SSA and the SSA as a whole. Yeah, those two. But you see, the Commissioner of Police and the Chief of Defense, they are not civilians, and that is where I think it is even more important here. That is not a civilian organization, TTPS, and they are one of the authorizing officers for Intercept. The CDF, the Chief of Defense, also is under statute, is not civilian. They, the other authorizers, for the head of the SSA, and in fact the whole of the SSA, unless you tell me otherwise, will be civilian. They'll be persons on contract. will share with us your org chart, how the staff is to go in, and of course, as I mentioned, the how you will get a director into place. So these are the key issues, as I'm saying, where we are willing to work with you to make this a better piece of legislation. We support the intent and purport of the bill, but we do feel that there is room for improvement, and I see you nodding your heads. There is room for improvement when it comes to, as I said, the whole issue of the database of persons involved in crime. What does involved mean? What does involved mean? No, seriously, we're dealing with law. We're not talking about, on the street you're talking to somebody and hey, so-and-so is involved in crime. We are in law here. If you want, you would need, in my respectful view, to put something more concrete when it comes to dealing with involved. It says response for maintaining databases of persons involved in serious crimes. The serious crimes defined in clause 3. You may want to look at changing the word involve, and perhaps we need to note that the terms maintain and involved in your phrase there of persons involved in serious crimes, these are not defined anywhere. So your database is not defined, and all those questions I raised previously as to where, the when, the how, by whom, with respect to collection, first of all, storage, custody, destruction, dissemination, all those issues arise from what do you mean by maintain? And then the second part, database. What is to go into the database that I asked you about? Biological, biometric, ethnic, all the other things that I raised previously. So the what is to go into the database, we don't know. As to how it is maintained, again, I raised those issues. And now we come to the word involved in that phrase of maintained databases. None of the words are defined in your proposed statute. Nowhere else in the parent law itself is it defined, and certainly not in the amendment. The term involved, as I say, is ambiguous. It is subjective. It is a subjective connotation. It's a subjective connotation. I think it will permit too much discretion on the part of the SSA to use virtually any information whatsoever, even if it is hearsay and or if it's other legally inadmissible information, to make a determination on whether a person is involved in serious crime. I submit respectfully that the term involved should either be qualified either by way of an objective criteria establishing the type of evidence or information that may be considered by the agency in making a determination that the person is involved, or you can do it also by reference to a person being charged and convicted with a serious offense defined under the proposed amendments to the SSA. So there are two ways, not necessarily alternative, but can be in both ways that we can look to find a proper definition of what we mean when we place in this word involved, or we can find another word, as I say, that will give us objective criteria in establishing the type of evidence or information to be considered by the agency. These are my comments. I want to thank you, Madam Speaker, for the time taken. I want to say we are totally prepared to work with the government, to cooperate with the government, because we do believe, given the situation, I mean today, I think as of yesterday, there were 101 murders. Even one murder is unacceptable, perhaps much less for 101. And we need, can you remember, I just have 1 minute. Yeah, that's very ghastly. I mean, what kind of horrible person, you murder someone, you cut them in half, you cut off the head, a woman, and you place them in a barrel. I mean, where has our country gone? Where is it going? And so we are willing to work with you on this. And I ask you to take up the officer, and we will work together to try to bring a measure of decrease with respect to the crime rate in Trinidad and Tobago. I thank you very much.
Member for point Fortin.
Thank you very much, Madam Speaker. Thank you for the privilege to participate in this debate for the proposed amendment for the Strategic Services Agency Bill 2016. This bill, which seeks to expand the 2015 Act, really to improve, Madam Speaker, the security of Trinidad and Tobago. Madam Speaker, I want to thank the Attorney General for his contribution, and I also want to thank the member for Siparia for her contribution to the debate, Madam Speaker. I noticed that the member for Siparia mentioned her concern with respect to the role of the minister and the appointment of director, and member for Siparia, that has been taken note of. I also want to mention that with respect to your concerns about the present director, in terms of his qualifications, he in fact has an MBA, and he is a graduate of the U.S. Army Command and General Staff College. And he's also a civil engineer. He's also an engineer. But Madam Speaker, he's a graduate of the U.S. Army Command and General Staff College, which is a one-year program. And during that program, part of the instruction, part of the courses is in fact intelligence and intelligence gathering analysis at the national level. So he does have some experience and training with respect to intelligence, if I may say so, Madam Speaker. Madam Speaker, this bill seeks in fact to transcend all party and political lines, and I'm glad to see the member for Siparia in fact saying quite clearly the support for this bill. Because at the end of the day, Madam Speaker, this bill seeks to deal with the national interests of Trinidad and Tobago. It is wider and broader than all of us. It is in fact, Madam Speaker, it deals with, to a large extent, what is happening in our information age, what is happening in our technological age, what is happening with respect to international terrorism, what is happening to crime and criminality in Trinidad and Tobago. And that, Madam Speaker, speaks to something that is wider and broader than all of us. What is in the national interest of Trinidad and Tobago? Some 30 years ago, Madam Speaker, Henry Kissinger once asked the American people, what is it in our interest to prevent? What should we seek to accomplish? Madam Speaker, I want to submit today that it is our interest today to come together to treat with the many issues of crime and criminality in Trinidad and Tobago. That is our national interest, Madam Speaker. And I heard the member for Siparia talk about the issues of crime. Crime right now, Madam Speaker, is intolerable. All of us cannot really tolerate the amount of crime in Trinidad and Tobago today. And so it is important for us to come together to treat those issues in a non-partisan manner, Madam Speaker. There is no area of public policy, Madam Speaker, that is as important in terms of manpower, money and resources as national security. No, nothing really has as much controversy as national security. Almost every day there are issues of national security in our print and electronic media. And so for this government, there is no greater role, no more important obligations than the security and preservation and the safety of citizens of Trinidad and Tobago. It is in fact a foundation of prosperity and the best assurance that we can ensure that future generations continue to live in harmony. And so, Madam Speaker, when we look at the strategic landscape, when we look at what's happening in terms of the characteristic of the security environment in Trinidad and Tobago, it is characterized by illegal guns, illegal drugs, gang violence, youth violence, money laundering, transnational organized crime, terrorism, illegal migration. Madam Speaker, the environment is charged with a number of issues and a number of challenges. And so, while we deal with it in an operational context, it is important for us to also ensure that there is an enabling legislation to treat with the issues of national security. This bill today, Madam Speaker, the expansion of the Strategic Services Agency Bill 2016, allows for a different kind of approach, but a complementary approach to deal with issues of crime and criminality. So while we deal with the operational aspect, this enabling legislation will also give us the ability and the capability to treat with the many issues that confront us, Madam Speaker. Madam Speaker, this government understands the impatience of the citizens, but as a responsible representative of the people, we believe that our initiatives must be executed within the legal framework. This government was accused some time ago of establishing the Special Anti-Crime Unit of Trinidad and Tobago in the absence of a legal framework. I think that has already been covered by the Attorney General. In fact, it was done with some degree of legality, and I will not go into that. But I said, allow us to get this right a second time. Let us get it right a second time to ensure that whatever agencies, whatever institutions that we create, whatever institution that we establish, it is done so within a legal framework. And that is the purpose for this bill, Madam Speaker, to ensure that this entity, the Strategic Services Agency going forward, the expanded version of that, is done so within the appropriate legal framework. And this is the purpose of this bill, Madam Speaker. Madam Speaker, the purpose of the bill, as mentioned, is in fact, and if I may read, Madam Speaker, with your permission, it seeks to expand the remit of the Strategic Services Agency by including broader law enforcement coordination and intelligence functions. Clause 3 of the bill broadens the scope and functions of the Strategic Service Agency by including an expansive definition for serious crime. And the AG has already covered that, so I will not go into it, Madam Speaker. But, Madam Speaker, when one looks at the historical perspective of the bill, when one understands that what has taken place before, and why is there a need for the expanded version, but why there is a need to expand the remit of the Strategic Services Agency, one must recall that the Strategic Service Agency was convened, was established in a time when internationally, throughout the entire world, the concern was based on drugs and illicit drugs. In fact, it was during that time that the United Nations Convention Against Illicit Trafficking in Narcotic Drugs and Psychotropic Substances 1988 was in fact convened. And most of the countries in the world, therefore, came on board to ensure that within their countries there's a national focal point. There's a focal point of contact established through agencies as a Strategic Services Agency to deal with drugs, illegal drugs and psychotropic substances. That's the background for the Strategic Services Agency. Madam Speaker, today the world has changed. The world has changed dramatically and perhaps materially. But not only the world has changed, Madam Speaker, the security climate has changed to a large extent. And therefore there must be the creation of different kind of institutions, different kind of entities to treat with the changing national security landscape, to treat with the national security environment, Madam Speaker. And therefore, in order to adapt, in order to change and to treat with those issues, one such attempt, Madam Speaker, is the lane of this bill today, the expansion of the Strategic Services Agency Bill 2016. So, Madam Speaker, the proposed amendment to this bill will help fashion this national security entity to fill a critical and, in fact, a cohesive void in the considered attack against crime in Trinidad and Tobago. Madam Speaker, this government, in coming into office, in fact, found that the present establishment of the Strategic Services Agency was in a bit of disarray. In fact, Madam Speaker, one would not want to go back into a number of situations that took place then, but merely to touch on the service. Because there are a number of issues to grapple with in terms of the dismantling of the number of security institutions post-2010. Between the last 5 years, we have seen a sort of mingling of different kind of institutions. The National Operations Center, the Security Intelligence Agencies, remnants of the Special Anti-Crime Unit of Trinidad and Tobago. And therefore, Madam Speaker, there was a bit of an absence of conceptual clarification in terms of how these entities were supposed to gel together, how were they supposed to deliver together to deal with the issues of crime and criminality in Trinidad and Tobago. And what this bill is trying to do, what this bill is attempting to do, is to give the legislative framework to ensure that all these different strands that were there in the Strategic Services Agency between 2010 and 2015, all the strands, the National Operations Center was in a silo. The Security Intelligence Agency in another silo. The remnants of SORT in another silo. And with the best of intentions of the last administration, they weren't able to pull that together in a concerted whole. And so what this bill is attempting to do within a legal framework is in fact to pull those units together to ensure that we have a cohesive whole. Because at the end of the day, the entities themselves can produce and will be able to produce what is required to treat the issues of crime and criminality in Trinidad and Tobago, Madam Speaker. Madam Speaker, I know that we have the support of the members for Siparia. And I knew that even before she said that, Madam Speaker, because I recall that she herself had some views in 2010, Madam Speaker, in accordance with the Hansard of dated Friday, November 12, 2010. She in fact said, and I quote, "Lack of coordination and unnecessary duplication of effort and resources are existing in the present environment." So there was a recognition then that there was a lack of coordination and a lack of effort. And so it's this same lack of coordination and effort that we recognize today that allow us to come forward to deal with that in the manner that we're dealing with today, Madam Speaker. I again quote from Hansard. In fact, when the member again for Siparia mentioned that, again the same date, Madam Speaker, November 12, 2010, quote, "Hence they brought no legislation to this Parliament to legalize such an important law enforcement unit." So there was a recognition then that there wasn't legislation for such an important unit, the then Strategic Services Agency. And so we too recognize that we need to put the legal framework in place. And that, again, Madam Speaker, is the reason for this government approach in the shortest possible time to ensure that whatever institutions we put in place to deal with crime and criminality will be done within a legal framework. And this is what this bill is serving to do, Madam Speaker, to ensure that this government, whatever we do it within a legal framework, Madam Speaker. Madam Speaker, in any field of endeavor, there must be conceptual clarity. Because conceptual clarification is in fact the indeterminable prerequisite to getting things done effectively and efficiently. In other words, Madam Speaker, in anything that we create, there must be what I call, first of all, a mental creation before a physical creation. What has happened in the past, quite frankly, there was an absence of that conceptual clarification. What is to be? What should exist? What do we want the agency to look like? And without that clarification, without that conceptual clarification, it means therefore that we are going down different kinds of roads with no end in mind. And so this entity today, the expanded remit of the Strategic Services Agency, is clearly based on a conceptual clarification. It's based on an understanding beginning with the end in mind. What do we want that agency to look like? What do we want them to deliver? And truly, Madam Speaker, we want that agency to work with and to complement the law enforcement agencies in Trinidad and Tobago, to work with the other agencies of the Ministry of National Security with a singleness of purpose and intention, and that is to treat with the issues within the environment of crime and security in Trinidad and Tobago. That's the end state, Madam Speaker. How can they deliver? How can that institution complement? How can they contribute to treat the issues of crime and criminality, working with the other institutions of national security? That, Madam Speaker, is the end state. And understanding that concept, understanding what is the purpose of that entity, we recognize that we have to do so in a certain manner, both in terms of staffing, both in terms of directorship, and also, Madam Speaker, in terms of creating the legal framework for them to do their job effectively and efficiently. And we did so, Madam Speaker, not in the absence of looking at research, not in the absence of looking at the very same reports that went before us, in terms of the Rush report. And yes, member for Siparia, we looked at the Gibran report also. And there were some commonalities in both reports going forward. And there were some recommendations going forward in both reports. In fact, both of them, there are some similarities. And in considering those two reports, and considering the reason and the threat analysis in Trinidad and Tobago at this point in time, we believe that the agency is best suited, Madam Speaker, by putting together the whole aspect of the different agencies, the National Operations Center, the Security Intelligence Agency, the National Security Training Academy, into one cohesive unit. Because at the end of the day, what the National Operations Center brings into the table is in fact that common operating picture, that situational awareness that will inform a response, an integrated response. What does the National Security Training Agency bring to the picture, brings to that institution? It brings a training at a different level. It brings training not only within the agency, but throughout the national security apparatus. But it brings dedicated training that is dedicated and focused to deliver in a certain kind of environment, Madam Speaker. What does the National Intelligence Agency bring into that mix, in that organization? It brings the intelligence focus. Because at the end of the day, we speak about intelligence-led operations. But as it exists today, and as the AG pointed out, we have a number of parallel organizations that deal with intelligence in today's security environment. And within those parallel environments, therefore there is no concerted effort. There is no way in which they are incorporated into the whole. And what this agency is trying to do, what it will be doing in fact, is ensuring that intelligence is placed in an area where it can be coordinated and cooperated, where it can be analyzed, where it can be disaggregated, and then sent back into the operation environment at the national level. And this is important, Madam Speaker, in going forward, because we talk about intelligence-led operation, yet we didn't have that kind of entity at the national level, one in which has the remit and possesses the skills to take information converted into intelligence. Not only that, Madam Speaker, but again, we are state among state in the international environment. Where is the agency that deals with or relates to our international partners insofar as intelligence is concerned? And so this entity, in terms of the National Intelligence Agency aspect of the SSA, would be that connectivity between Trinidad and Tobago and our international partners. And that is something that has been demanded of us by our international partners, Madam Speaker. Because for a large extent, they will not talk to us. They will not treat us until we have such an agency and one that is placed within a legal framework, Madam Speaker. And I emphasize, it must be placed within a legal framework in order for us to relate, in order for us to connect to our international partners. And so we put ourselves in a certain kind of environment where in terms of intelligence gathering, and today we deal with issues such as ISIS. We know of Trinidad and Tobago nationals who are participating in Faris. How do we rely? How do we get the kind of information to treat with them, Madam Speaker? We, as a country, don't have the kind of resources to reach out in Syria or those places. We rely to a large extent on our international partners to treat with us, to share with us those kind of information. But they will not treat with us. They will not share with us unless they are doing so in a legal framework in our own country, Madam Speaker. And hence the reason why when we talk about intelligence, when we talk about the National Intelligence Agency, it is based on putting it within this legal framework to treat the issues both internal and external to us. And I draw just one example, but there are a number of different issues pertaining to this. And so it is very important and very fundamental that this bill that expands the remit of the Strategic Services Agency be one in which we understand fully the implications in terms of treating with the many issues of crime and criminality in Trinidad and Tobago, Madam Speaker. It is one in which the attempt here is going forward is based on cooperation and collaboration. Not only internally, but I said externally also. It sets the pace, it sets the climate in which we can see a number of different changes. We can see the potential for more results in treating crime and criminality in Trinidad and Tobago, Madam Speaker. For far too long, we have gone through silos in Trinidad and Tobago. Far too long, we operated with a different kind of philosophy. We have to understand that in today's world, the world is doing it right now. It must be based on cooperation and collaboration, and that must come down to the lowest level of operation. Because it's the only way that we can treat those issues. And I am glad again when I heard the member for Siparia said that they're fully in support of this, with some areas of concern. But it is also a very good start, because it shows that we are put to a large extent. It shows that we're going beyond the partisan approach to crime, the partisan approach to security in Trinidad and Tobago. And I want to say that is a very good step in the right direction, Madam Speaker. It's a very good step in the right direction, Madam Speaker. Madam Speaker, the bill that we have in front of us, Madam Speaker, is one in which would allow us to operate also within our Caribbean regions, to treat with the many issues that confront us. It has, because, Madam Speaker, we are a country, we are an island, archipelagic state, and therefore part of our issues treating us is in fact our maritime borders. And what you're seeing there, Madam Speaker, is the connectivity between us and our neighbors, that again would allow us to treat the issues our closest neighbor. For instance, in Venezuela, we have established a high bilateral agreement with Venezuela in terms of a discussion group. And so part of that discussion is how do we share, how do we treat the information at a very high level. And in fact, one of the questions that came about in those discussions is that who do we talk to in Trinidad and Tobago? And the question on our side is who will we speak with in Venezuela? And based on that discussion, Madam Speaker, is based on it must be done at a very high level. And the entity must be one that is placed in a legal framework on both sides of the border. Because when you deal with information and intelligence at that level, there are certain kind of expectations, Madam Speaker. And so I draw those examples to show you the importance of this bill, Madam Speaker. The importance of ensuring that we have it within a legal framework. And I emphasize, we are quite comfortable with the operational framework. We can deal with the operational aspect. We can put boots on the ground. We can put troops on the ground. We can put law enforcement people on the ground. We can do so because we have that resources. But the more important thing, the more fundamental thing right now, Madam Speaker, is how do we do so within a legal framework. And I say to you, Madam Speaker, if I will, that this bill would give us that kind of legitimacy to operationalize the entity, the Strategic Services Agency, to allow it to complement the existing agencies of national security, Madam Speaker. Madam Speaker, when we look at the expanded Strategic Services Agency, we can see that it will focus to a large extent on coordination, on intelligence gathering and analysis, on the use of updated technology, with an intense focus on criminal targets, establishment of proper situational awareness, and common operating picture. And Madam Speaker, the strategy will of course demonstrate an ability and capability to deter and disrupt organized crime, recruit and retain quality people, develop and manage criminal and international intelligence, improve national coordination of incident management, and of course, deal with some aspect of crime scene operations. Madam Speaker, there will be, based on the agency's heightening of its detections and deterrence capabilities, development of strategic alliances, policy formulation, the deepening of domestic and international cooperation, information gathering that I mentioned a while ago, capacity building, and of course, specialized training and international cooperation, Madam Speaker. These specified objectives are all in accord with the needs of multilateral cooperation and international instruments developed to treat with us as part of the international security environment, Madam Speaker. Madam Speaker, in the aftermath of 9/11, the world changed with respect to coordination of entities. After 9/11, the United States recognized that they too were in silos. We cannot wait for something like that to happen to us before we take our necessary action. We must be proactive. And so, not waiting for 9/11, let us ensure that we too move forward in an integrated approach. Let us learn from their mistake. Let us understand that in order to treat the issues in a proactive manner, we must set the template. We must set the template for cooperation and collaboration, Madam Speaker. And this is what the bill seems to do. This is what this bill is about. Yeah. I'll put 5 more minutes. Yeah. Yeah. Madam Speaker, so in fact, we are in fact adopting that proactive approach. By coming today with this bill, Madam Speaker, is in fact a proactive approach to put together those institutions that are required, to put together those institutions that are necessary, to put together the institution that will complement our existing structures to treat the issues of crime and criminality, Madam Speaker. It must be, again, it was based on that aspect of cooperation and collaboration going forward. Madam Speaker, it's also critical to note that in the exigencies of national security necessitates that this umbrella-like composite coordinated mechanism will in fact unify law enforcement. It will bring together all the entities together under one shop, bring together under one area, Madam Speaker. And so if we learn from lessons, even in our own jurisdiction, if we learn our lessons from 1990, 1990 we had an attempted coup here in Trinidad and Tobago. And what of the debrief coming out from that said to us that we were in fact operating in silos. One area of the national security operators didn't know what the other was doing. And that's just here in our own local jurisdiction, Madam Speaker. Yeah, that was our experience in 1990 right here in Trinidad and Tobago. And so there are lessons for us right here, not if we could use from 9/11, but we have our experience right here, Madam Speaker. 1990, there were disaggregated intelligence sources. There was no coordinating body. If there was a coordinating body in 1990, Madam Speaker, we would have been able to prevent what happened to us as a country in 1990. The lessons are right here for us to learn, Madam Speaker. And I would say, Madam Speaker, that this bill and the results of this would restore public confidence. This would ensure that the country realizes that we're taking measures within, again, I always emphasize, within a legal framework to ensure that we have the institutions that are required, the institutions that are necessary to bring a certain kind of relief to us. See, Madam Speaker, the Strategic Services Agency expanded is not only about intelligence. It's about creating and crafting a response that is based on intelligence, common intelligence picture, and of course training and preparation. Institutional strengthening and capacity building is one of the measures that they would be instituting, Madam Speaker. And so, Madam Speaker, it is anticipated that this fusion of entities, the National Operations Center, the National Security Training Academy, the Security Intelligence Agency, the National Intelligence Agency, this fusion of these entities will be done to the benefit of the security environment, but the wider benefit of the people of Trinidad and Tobago. Because it will bring to the table something that has not really and truly been craftily done before, Madam Speaker. It will change the security environment. We now have what we call integrated response, but additionally, we'll have what is called intelligence, truly intelligence-led operation. And so, Madam Speaker, when one looks at what happens in other jurisdictions, we can take pattern. Because in almost any jurisdiction in the developed world, there are entities such as what we are trying to establish today. We have the FBI in the United States. We have the Homeland Security in the United States, Madam Speaker. We also have the Serious Organized Crime Unit, the National Crime Agency in the United Kingdom, Madam Speaker. Madam Speaker, when you look at internationally, in the United States, as I mentioned, we have the FBI. In Israel, we have the Shin Bet, an organization similar to what we're trying to create that deals with issues of crime, criminality within the jurisdiction of Israel. In Canada, we have the Canadian Security Intelligence Service. In UK, I think it was mentioned a while ago, the member for Siparia. So that there are in fact learnings internationally. There are in fact institutions internationally that do exactly what we're trying to do in Trinidad and Tobago. And I'm sure that what we're talking about is taking the best practices from these institutions, because there's no sense reinventing the wheel, Madam Speaker. There are institutions outside there that we can emulate. There are things that we can take from them in best practices. Because at the end of the day, what we're trying to do is truly to be proactive as a people. To be proactive, Madam Speaker.
Honorable, I have a point to open. Your 30 minutes have expired. May I inquire how much longer you will be before you wrap up.
3 more minutes, ma'am.
3 more minutes. So you give on the extension of time. Please continue.
Yes. Madam Speaker, I thank you for obliging for the 3 more minutes. I simply want to wrap up, Madam Speaker, by saying, in today's world, it is one of interdependence. It is one in which none of us can treat the many issues and challenges that confront us. And so, again, I want to thank the member for Siparia for saying that the support for the bill, but it also redounds to the wider Trinidad and Tobago. Going forward, it must be based on cooperation and collaboration, because the issues of crime and criminality is larger than all of us. Madam Speaker, I thank you very much.
Honorable members, I wish to inform this House of the passing of Mr. Lincoln Myers on March 15, 2016. Mr. Myers served as a member for St. Anne's East from 1986 to 1991. As we mourn his passing, I now invite the House to pay tribute to Mr. Myers. I call upon the member for St. Anne's East.
Thank you, Madam Speaker. Honorable members, at this time, on behalf of the government of Trinidad and Tobago, I would like to extend condolences to the family of former minister and former member of Parliament for St. Anne's East, Lincoln Myers, who passed away on Tuesday, March 16, 2016. Many persons have expressed what an honorable man Mr. Myers was, how he held fast to his convictions, and how he championed many causes for the betterment of the people of Trinidad and Tobago. Mr. Myers was truly a man of the world, and although in recent time he was out of the public eye, he kept abreast of current events both locally and internationally, oftentimes running a stirring commentary on his social media accounts. He was an advocate for renewable energy and sought to educate persons about climate change and the damage to the environment. He was passionate about the inclusion of all people and spoke out against people and institutions which he felt promoted division. It is to Mr. Myers' credit that whatever the issue, if he felt injustice or corrupt practices were involved, he added his voice to the call for change. One can suspect that it was this relentless fervor that propelled him to endure a 40-day fast in 1985 to highlight the need for what he thought was better governance. This unrelenting passion to champion one's belief will no doubt be among the many things Mr. Myers is remembered for, and is a lesson to us all as a people to stand firm in our convictions and relentlessly so. Thank you for all that you have done for this nation, Mr. Myers. May his soul rest in eternal peace.
The member for Tabakit.
Thank you, Madam Speaker. Madam Speaker, I also rise to pay tribute on behalf of my colleagues, and I'm sure thousands of others, to the late Lincoln Myers, former Member of Parliament, Minister and social and political activist. I wish to extend condolences to his wife, his children, and extended family members, as well as his friends and well-wishers. Madam Speaker, in the world, there are lots of persons who have strong beliefs. However, the ability to stand publicly for a cause which reflects those views are few and far between. You would agree that in societies like ours, which are still struggling for a level of maturity where political differences and opinions are concerned, there's a high price that one often has to pay for going against the establishment, and yet the ability of a society to evolve depends on the cause or causes for which you choose to be different. Lincoln Myers was strong, committed, and fiercely independent in his views, and it was his determination to bring about a new standard for public accountability in this country. In this regard, our society may not yet have fully understood nor appreciated his 40-day fast on the steps of the Hall of Justice. It is the accumulated efforts of several personal individual actions like his which eventually positions the mind of a society in the direction of evolving a higher national morality. His actions have helped to build the foundations for this higher morality in public affairs. The political history of Mr. Myers is well documented. He was a person who, though strong in his views, valued dialogue and was humble enough to respect the opinions of others, often in the interest of achieving a consensus. Lincoln Myers had the distinction of being the only person to have defeated a sitting prime minister in the famous NAR 33-3 victory in 1986. To do this meant that he would have possessed some special interpersonal skills and communication skills, and the ability to convince the electorate of that constituency that the political change which his party professed would have been beneficial to the nation, since that constituency was traditionally PNM. Throughout his life, though affected by the issue of mobility, his mind never stopped working, and he continued to contribute and nurture political thought and a vision for a more inclusive society. Despite the controversies which would have surrounded his thoughts on national service, controversy engendered more as a result of the feeling of insecurity by social groups. The idea of the need for national service as one avenue of contributing towards commitment to nation and love for country, of dealing with youth in discipline and citizenship, remains alive. In a country where so many good ideas are destroyed by controversies as a result of irrational thinking, with dispassionate thought, we may still one day see the value of the vision of Lincoln Myers. Lincoln Myers threw a pebble into the lake, and the water splashed and was dispersed in different directions. His efforts no doubt inspired, even unconsciously, those in our society who continue to work tirelessly towards morality in public affairs. His legacy has been written in his thoughts, his words, and his deeds. May the loving and compassionate divine bless his soul and bring comfort at this time to his family and friends. May Lincoln Myers rest in peace.
Honorable members, I endorse the sentiments expressed by both sides of this House. Indeed, Mr. Lincoln Myers will be remembered as an ultimate statesman in the development of Trinidad and Tobago and as a dedicated anti-corruption and good governance advocate. Honorable members, in paying tribute to Mr. Myers, we should recommit to the discharge of the high demands of service to our country. This House joins with his family and friends in mourning his passing. May I invite you all to stand and observe a minute of silence to show respect to the late Mr. Lincoln Myers. May his soul rest in eternal peace. I direct the clerk, you're all invited to have a seat. I direct the clerk of the House to send an appropriate message of condolence on our behalf to the widow of Mr. Lincoln Myers. At this time, I suspend the House for half an hour.
As indicated by the Speaker of the House, the 18th sitting of the House in the first session of the 11th Parliament that takes place on Friday, March 18th, 2016, is suspended. Stay tuned to Parliament Radio 105.5 FM and the Parliament channel. During the break, we feature some of our parliamentary personalities, and we expect to resume 30 minutes from the time of the break, which should be 5:02 p.m. Join us then. Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament. You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM. The Red House, situated in the heart of Port of Spain, has a legacy as the home of democracy in Trinidad and Tobago and contains within its walls a remarkable history. The historical significance of the building was further enhanced when, during recent restorative works, there was a discovery of archaeological relics and even evidence of indigenous burials. In order to preserve this history, careful consideration was given to the renovation of the building, which led to the Restoration Committee employing the services of an American architectural company to carry out specific restoration and preservative functions on the building.
Evergreen is a specialty contractor based in New York City in the United States, and we specialize in the restoration and conservation of decorative arts in buildings. So we work on ornamental plaster, decorative painting, works of art such as murals on canvas and on walls. We've worked in Port of Spain at Queen's Royal College, and recently in the United States we've worked at the U.S. Capitol and the United Nations building. What's interesting to me is that the red plaster that's at Queen's Royal College is here at Red House, and it gave this building its distinctive red color before it was painted over. Our objective is to determine historic colors used in the interior of the building, and that would include paint on plaster and possibly wood, or we found that a lot of the wood surfaces were originally stained or clear coated, so you were meant to see the grain of the wood. And we're also tasked with understanding the exterior color scheme, basically anything having to do with the original color of the building as it was articulated after 1903. So for the finishes analysis and determining the historic colors, we use two main techniques. One is collecting paint samples from the walls and ceiling and other features, and we'll examine those to determine the different color schemes over time. And we also conduct what we call exposure windows in place. And an exposure window is when we remove layers of paint a bit at a time so we can see on the wall what different colors and finishes were placed. Another goal of this project is to preserve the plaster molds that were created previously by Evergreen. In the south chamber, the ceiling was dismantled and the ornamental plaster pieces were cast, meaning we made replica molds, I should say, for those pieces so that in the future we can cast replicas of pieces that have been damaged and then place them back in the south chamber exactly as they were originally. I think the most interesting thing about the Red House to me is the exterior red plaster. The red color you see today is achieved through multiple layers of paint, which has a tendency to fade over time as any paint will. But the red color that this building has was originally imparted by a very deep red plaster. It's very beautiful material. The next step for me is I examine the paint samples under the microscope and I cut them in cross-section, and that way I can see the paint layers one over the other, so I can determine what colors were used over time in the Red House.
The Red House Restoration Project has uncovered many findings, and the team at Evergreen's own meticulous investigation will add to the details that will help in restoring the Red House to its former majesty.
Our democracy was created for us to be free.
And
we, the people of Trinidad and Tobago, have asserted our belief in a democratic society
in which all persons may,
to the extent of our capacity, play some part in the institutions of national life, and thus develop and maintain due respect for lawfully constituted
authority.
Welcome to the Parliament, where the people whom we elect come to debate issues of national importance and decide on what best represents the voices, the concerns, and the best policies for the citizens of our country. We are going to examine two important figures in our Parliament, our presiding officers.
Have you ever heard of the presiding officers?
No. Who are they?
Well, the presiding officers are responsible for the smooth functioning of the many proceedings of our bicameral parliament.
Bicameral?
That just means that we have two legislative or parliamentary chambers, the Senate and the House of Representatives, for checks and balance.
The roles of the presiding officers are truly impressive. These officials hold the fourth and fifth highest offices in our land. They are the President of the Senate and the Speaker of the House. Ideally, the Senate seeks to represent and take into account the views and interests of those in society who may be insufficiently reflected within the elected House. The House of Representatives is made up of the elected representatives of the 41 constituencies.
House of Representatives?
That's where the members of Parliament who've been elected to represent their constituencies meet to debate national issues.
So, what about the Senate?
The Senate comprises of persons specially appointed by the President of Trinidad and Tobago, the Prime Minister, and the Leader of the Opposition.
So, the President of the Senate presides over the Senate.
And the Speaker of the House presides over the House of Representatives.
And together, they are the presiding officers.
They are the first ones elected by their respective houses after the general election, so that the business of the houses can proceed.
The presiding officers ensure that all parliamentary debates are conducted in an orderly way. Parliament members must catch the eye of the presiding officer to be granted permission to speak. And all parliamentary members must address the presiding officer with respect as Mr. or Madam Speaker, or Mr. or Madam President, because presiding officers have the highest position in any parliamentary house.
The presiding officers also ensure that parliamentary rules and the law are followed during debating, regulating the time for speaking, so that Parliament runs smoothly. They also have the final say on any dispute using the rules of procedure. So that is why they're called the presiding officers?
Yes, because their main function is to be the referee of each house, as they guide and regulate the proceedings. This is symbolized by the maces of each house.
Maces?
Each house has an ornamental mace as a symbol of the presiding officer's authority.
Why a mace?
Well, it has its roots in European monarchy as a real weapon to guard the monarch. But as weaponry and government evolved, it became a symbol of authority vested in democratic government.
The ornamental mace is carried in and out of Parliament by the Marshal. It precedes and leaves with the presiding officers of each house. Each house has its own special design on its mace.
Other than presiding in the chambers, the presiding officers also have ceremonial duties,
where they participate in the opening of Parliament and sometimes lead major parliamentary delegations to other countries or attend regional conferences here in TNT. High commissioners and ambassadors come one and come all to pay courtesy calls on the presiding officers in our country to foster deeper relationships between nations and legislatures. Additionally, the President of the Senate can in fact fulfill the role and duties of the President of Trinidad and Tobago when he is out of the country or ill. So that is a lot of work for just one role. Do they have any help?
Well, there's the Vice President of the Senate and the Deputy Speaker of the House, in addition to the Clerk of the House and other parliamentary officers who are well versed in parliamentary procedure and rules. There are also ways in which other key personnel in Parliament assist the presiding officers in the execution of their third major function.
You mean there's more?
Yes, the presiding officers are also the administrators for the Parliament.
They ensure that all is secure in the Parliament building and its surroundings for the safety of its members. The Marshal of the Parliament as well as the Parliament Police Unit are charged with this responsibility.
Both presiding officers also chair several committees of Parliament, such as the Committee of Privileges, which deals with ensuring that the rights that are afforded to members are not abused in any way. There's also the Standing Orders Committee, which reviews the standing orders from time to time to make changes to the rules that govern how Parliament functions.
So how do you know what to look for in a presiding officer?
Well, they must be impartial, independent and authoritative.
The presiding officers have big responsibilities in the Senate and House of Representatives. And you know what that means? That they must have excellent qualities. Once elected, the presiding officers must put aside all party affiliations and be impartial in every ruling made to make sure that every voice is heard with equal representation, balancing the majority with the minority. They must embody the authority invested in them, allowing for respect from one and all, as they are the representatives of the Parliament itself in its powers, proceedings, and dignity.
The presiding officers have important roles in maintaining checks and balances in the Parliament, the seat of our democracy.
We hope that you got a glimpse into how much responsibility a presiding officer has, and that maybe one day you too might aspire to be elected to such an important office to serve your country.
While viewing a sitting of the House of Representatives or the Senate, you may have noticed someone walk into the Parliament chamber holding a metal staff over his right shoulder while announcing the arrival of the presiding officer. Either gold or silver in color, this staff is known as a ceremonial mace, and its presence in the Parliament chamber symbolizes the authority and privileges of the House. The origins of the ceremonial mace date back to the 13th century, when the mace was used as a weapon by a royal bodyguard to protect the king. The person entrusted with this responsibility was known as the Sergeant-at-Arms. Between the late 1300s and early 1400s, the mace became increasingly decorative and was adorned with precious metals. The civic mace, as it was called during this period, was no longer used as a weapon, partly due to the use of heavy armor becoming obsolete. Then, during the 14th, 15th, and 16th centuries, the mace underwent several transformations which changed its shape, style, and use. For example, the flanged end of the mace, the top end, which was specifically designed to aid the bearer in war, was replaced with precious metals. Today, the mace is used in many parliaments across the world and bears much significance as it did in the olden days. On the day of a sitting, the Marshal of the Parliament holds the mace over his right shoulder and walks ahead of the presiding officer at the start and end of a sitting. In the chamber, the Marshal announces the arrival of either presiding officer and places the mace on the upper brackets of the clerk's table, signifying the beginning of a sitting. There are a few instances where the mace is moved from the upper to the lower brackets or removed from the House. At the commencement of a new parliament, the presiding officer's chair is vacant, and as such, the mace is placed on the lower brackets until a new presiding officer is elected. The mace is also removed from the upper to the lower brackets when a sitting of the House has been suspended. After the debate on a bill is concluded, the bill is referred to a committee for consideration of its details. When it is sent to a committee of the whole House, the presiding officer must vacate his chair and sit in the clerk's chair. The marshal then removes the mace from the upper brackets to the lower brackets of the clerk's table. At the end of the committee stage, the presiding officer returns to his chair and the marshal replaces the mace in the upper brackets. Parliamentary practice dictates that no sitting of either house can take place if the mace is not present. Handling of the mace by someone other than the marshal or a person performing such a role in his absence while the House is in session suggests willful disobedience to the rules of the House. The mace which sits in the House of Representatives at the Parliament of Trinidad and Tobago was crafted by silversmith Messrs. Garrett of England in 1899 and donated to the Legislative Council of Trinidad and Tobago on June 5, 1899. It is silver gilt and has a two-dimensional silver carving of the coat of arms to the top. Its knob or head is ornamented with carved motifs which depict the landing of Christopher Columbus in Trinidad. At the top of the stem are the words Legislative Council of Trinidad and Tobago, under which are the names of the 24 subscribers to the mace. When the country achieved independence in 1962, this mace was donated to the House of Representatives. 37 years later, in 1999, the mace celebrated 100 years. Upon the suggestion of the then leader of the opposition, Mr. Patrick Manning, the House Speaker, Hector McLean, authorized to have the names of all the members of the Fifth Republican Parliament engraved on the bottom end stem of the mace. The mace belonging to the Senate may not bear the same historical significance as its silver counterpart, but its relevance to the chamber is undeniable. In 1962, a committee was appointed to select the design for the mace. Local metal craftsman Ken Morris submitted designs for a temporary mace, which would have been created for the inauguration of Parliament on August 31, 1962. After meeting with local artist Carlisle Chang, Mr. Morris and Mr. Chang submitted designs for the creation of a permanent mace. The decision was taken by the committee appointed to consider designs to hire highly skilled local artisans to produce the mace, as it would be considered an incentive for other craftsmen. Unfortunately, discussions on the mace reached a standstill. In 1963, it was agreed to immediately purchase a mace for the Senate because of the dissolution of the Senate of the federal government, whose mace was being used in the interim. Finally, in 1966, Mr. Chang's designs were sent to Messrs. Thomas Fattorini Limited in the United Kingdom to sculpt a mace for the Senate. This mace is still being used in the Senate today. The design of the mace of the Senate was loosely based on the mace of the Parliament of Tanzania and adapted to local purposes. Its features include 2 copies of the coat of arms, a 3-dimensional figurine at the top, and an engraving of the national emblem on its knob. The words Senate of the Republic of Trinidad and Tobago are also engraved in the mace's knob. 4 round panels along the stem of the mace depict the oil industry, the sugar industry, the cocoa industry, and the symbol of the local manufacturers association. At the top of the base of the stem is an engraving of the national flower, the Chiconia, and the Anthurium lily. The floron or end of the mace is in the shape of a cocoa pod. This mace is gold in color. Used as a weapon in ancient times to protect the king, today the presence of the mace in the chamber symbolizes the authority vested in the houses on behalf of the people of Trinidad and Tobago. Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.
Parliament Outreach.
One thing I remembered was the way in which Parliament takes an issue and deals with the issue. You know, sometimes from an area our community fights about, we have so much resources, and why does an issue take so long to be dealt with, and how how the President of the Senate handled the issues and the procedures in which they take an issue and deal with it. That was my most memorable.
From this lecture today, I learned about the different parts and the arms of government and how they react to different circumstances and the decision making and who takes up the decision making to Parliament.
Parliament Outreach. Check our website for showtimes, ttparliament.org.
In the heart of Port of Spain, a small but significant structure can be found tucked away on Sackville Street. This seemingly innocuous little building is one of the few remaining examples of our Spanish architectural heritage and likely part of our governmental history. It is believed to have belonged to the illustrious board of the Cabildo, an administrative council that existed during Spanish colonial rule. When Trinidad was a colony of Spain, the Cabildo exercised wide executive powers, but were mainly responsible for the governance of the bigger towns.
There was a small council of partly elected, partly appointed gentlemen. You had to be male, you had to be white, you had to be a Christian, a Catholic Christian, and you had to own some property in the city. Those were the requirements.
In 1797, when the British seized power from Spain, Governor Colonel Thomas Picton chose not to abolish the Cabildo. On old maps of Port of Spain, this building on Sackville Street was labelled the Cabildo. During restoration work, carbon dating confirmed the building was approximately 200 years old. But its actual function continues to be a source of speculation.
Cabildo buildings were probably built in the early 1800s, but definitely Spanish style. The architecture is quite clearly Spanish. And there's good reason to think that the Cabildo did meet in that building.
However, restoration architects have a different opinion. Their examination of the foundations of the Cabildo building found it was once part of a larger complex.
On some of the old maps around 1800, we see it called the Cabildo, but it's far too small a building to have been the headquarters for the illustrious Cabildo. It's no way. So we suspect that it may have been an out office, maybe a registry for birth and deaths, for instance, not necessarily where the Cabildo met, where the town hall was. Or it may have been a building that after one of the fires, because we know that the town hall burnt down more than once, it might have been used as a temporary quarters, which is why we now think of it and it's now called the Cabildo.
So I mean, it's unlikely that it was the Cabildo. It may have been owned by the Cabildo. It may have been owned by somebody who was senior in the Cabildo, which I strongly suspect. Or maybe the Cabildo had a series of houses for their staff or their councillors or...
Despite speculation on its usage, the building on Sackville Street is undeniably an important example of our Spanish architectural heritage. Built in 1826, the details of the building are typical of domestic urban structures seen in other Spanish colonies.
The Cabildo house is Spanish style. There is a small fountain in the courtyard. It opens directly onto the street and there are very, very thick walls. There is that whole very Moorish Latin feel to it. And it is one of the examples of Spanish architecture in Trinidad that have survived.
The building is introspective in terms of style and was well designed for the tropics.
It's a delightful space, really. You don't even think that you're going to, when you walk in here, you're going to suddenly come onto an interior courtyard. And if you go again back to Venezuela, Cuba, the floor plan is typical. That you walk in, you pass one or two rooms, and it just opens up in the middle. Tropical architecture, the air comes through the door, it circulates, and it goes up through the middle of the building.
By the 1830s, however, the British wanted to establish firmer control over their colony and set about Anglicizing Trinidad, making laws and institutions more British. As they began bringing an end to slavery, they came up against strong resistance from the Cabildo.
Now, the Cabildo, stuffed with slaveholders, used the institution to fight tooth and nail against Britain's slave policies. So for those reasons, plus the fact it was a Spanish institution, clearly its time was limited. It was abolished in 1840 and replaced by an English type of borough council.
The Cabildo building was left abandoned for many years and fell into ruin. It was saved from demolition in the 1980s by the efforts of the Trinidad and Tobago Institute of Architects, spearheaded by Adrian Camp's Campins. Today, the Cabildo building has found new life as a law museum. Handcrafted mesquite furniture was made for the building in 18th century style. A sculpted Spanish-styled fountain was installed where the original fountain stood.
Turning it into the law museum, which has been done, has given it a lift, a boost that is extremely important and will make people conscious of the importance of, the restoration of old buildings.
Many of Port of Spain's historical structures from 200 years ago have been destroyed by fire or urbanization over the centuries. This is why the Cabildo is so important in our architectural landscape.
Even though this building that we call the Cabildo was built during the early part of the British era, it is the only thing we have left of Spanish influence in Port of Spain. So it's important to keep it, to remind us that we do have a Spanish heritage, and that the Spaniards were here before the British came.
Now a listed heritage site, this small but significant building is a link to our Spanish colonial past. With its new function as home to the Law Museum, hopefully it will be appreciated for generations to come.
You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
Honorable the Speaker.
A15. The member for St. Augustine.
Thank you very much, Madam Speaker.
Yes, sir. Senator.
Let me congratulate, first of all, the efforts of the Attorney General, who, with his normal eloquence and erudite way, was very persuasive in his efforts, for which I consider to be a noble effort, and certainly falling on, of course, the Leader of the Opposition. No way can I ever hope to challenge her dulcetic tones with the precision of a senior counsel to have dissected the issues in this matter, and the gentlemanly noble member for Point Fortin with his delivery, and I'm sure at the core, we all here want what is best for Trinidad and Tobago. And we, on this side of the view, and I speak for myself as a member of St. Augustine, and of course having heard the leader of the opposition, that this is important legislation. It is necessary legislation, but I'm reminded that the road to hell is paved with good intentions. We can work it out, without a doubt. And I want to add my voice, Madam Speaker, to the proposition that this really should be before a joint select committee, because notwithstanding the best intent, there are serious dangers within the bosom of this legislation. Embraced as it is, from 1995, as we were reminded by the Attorney General, this SSA was created to add legitimacy to an OSS, which had gone in its operations without legislative cover. But more significant than that, it was created out of a need for to deal with the international drug trafficking issues. And it has gone that way for a long period of time. But to hear the Attorney General suggest that because there was no call for a constitutional majority when the matter was first raised in 1995, and to parachute it one generation later into a modern expectation of how we do business, I think he erred a little. And I think we need to revisit why it is necessary for us to have a constitutional majority support on this matter. Without wishing to be repetitive, the member for Siparia dealt with it. But it is worth repeating. Because what has happened from that era and the legislative cover for a very limited aspect has now mushroomed into something far more dynamic, far more encompassing, and therefore the need to be cautious as we move forward because we want to make it right. We do not wish to have legislation as we proceed that is subjected to pitfalls. And to be reminded equally that the opposition of the past, now government, supported 97% of the legislation brought. Speaks well, first of all, that the government of the last administration brought good legislation, and two, that the opposition then acted in the interest of the country to do what they thought was necessary. And that is why we must have this sense of cooperation, because as we stand, whether in government or opposition, we are in the People's Parliament, and whatever we do must be to their benefit. Now, back to the issue of the need for a constitutional majority for this. It's very simple, you know. Here we have the director of the SSA, and I will deal now with the, not now, but a little bit later, with how one is chosen for that job. But the most significant thing, it is not that person as much as the power that you give to that person. And what is the power we now give by this legislation if it should pass? This person now will have authority with his agency to use the interception of communications authority. What this means is simply that that agency, the SSA, can now venture into surveillance, not just in relation to drugs, but in relation to all quote-unquote serious crimes. And we have heard now that serious crimes will be determined at any offense which attracts a minimum of 5 years imprisonment. I want to tell you, the law has so changed that there are very few offenses apart from maybe obscene, well, there isn't a charge called obscene language, but annoying language and some traffic offenses that do not attract less than 5 years. Simple assaults, receiving stolen goods, of course, is high penalty case. And I could go on and on, but there are very, very few offenses that fall under that. So therefore, the remit of this agency is so wide for them to be able to survey. And the Attorney General made passing reference to two things. And it is quite important to note. Intelligence, and maybe we should really explore what that means, because it is just the opposite of what many people believe. Intelligence really is not intelligence. It is really old talk, rumor, vapor, as I call it in some cases. So I'll give you one prime example of what triggers a possibility for surveillance. Under the old law, you had to have some information, some rumor even, of someone being involved in trafficking of narcotics. But if we had to pass this legislation, almost any offense that you could imagine, apart from driving and traffic offenses and annoying language and so, can trigger surveillance of any individual. There's a fallacy about it. And I would ask anyone to show that I'm wrong on this. That with this new legislation, under the wide ambit called national security, they can survey anyone. And if I may refer, my lady, to the Interception of Communications Act, Section 6, 2B. And to put it in context, maybe I should read all of it. Except as provided in this section, a person who intentionally intercepts a communication in the course of its transmission by means of a telecommunications network commits an offense and is liable on summary conviction to a fine of $500,000 and to imprisonment for 7 years. Notwithstanding any other law, a person does not commit an offense under this section if the communication is intercepted in obedience to a warrant issued by a judge under Section 8.1. B, and this is the germane issue here. The communication is intercepted by an authorized officer. And certainly, by definition, the authorized officer includes the director of the SSA. But here it is, in the interest of national security. What does that mean? What does that really mean? And one can appreciate you cannot scientifically define, and it's left up to the conscience of that person and their interpretation of their description of national security interests for them to be able to start to survey. Both electronic and human intelligence, ELINT and HUMINT, as we call it. It goes further. For the prevention or detection of an offense for which a penalty on conviction is imprisonment for 10 years, which is inconsistent, of course, with the SSA Act that we know, that is now before us, which says 5 years. And includes an offense where death, imprisonment for the remainder of a person's natural life, and so on. For the purpose of safeguarding the economic well-being of the state. For the purpose of giving effect to the provisions of international mutual assistance agreements. So now, what happens is that this director of the SSA and his agency can use any of those definitions for any offense. Any offense. It need not be the classic drugs. It need not be any of those name offenses of trafficking in persons, corruption. It could be any offense, and they can start to survey. Now that's a serious thing, because that legislation, the interception of communication, needed a 3/5 majority, and for good reason. But here you have a director under another law who can be appointed under a law of a simple majority using a nuclear weapon. And that is why it is inconsistent that that person can be chosen from by legislation from a simple majority, but yet exercise the power that can only be given by a constitutional majority. Now, let us examine what we are dealing with here. In 2010, when the People's Partnership Government came into government, there was an alarm raised, of illegal wiretapping in the society. Whereas we've heard then and we've heard today, a Chief Justice's telephone and his wife bugged. Sitting members of the Glen cabinet bugged. Well, we'll do that. The president, the head of state, members of the media, no one was safe. And that wiretapping or eavesdropping had been perpetrated by the SIA at the time, which had no legal recognition. Yes. So that, you know, I may change my tone as we proceed if I'm being interrupted, I want to say. Because there's a lot. I'm not here to point fingers or anything like that. But it was another PNM administration. And we got the support then of the opposition, led by the present Prime Minister, to deal with that and to create the Interception of Communications Act.
He was a subject of it.
He too was a subject. But it must not be only because one is a victim that you will support something.
You cannot disprove it.
So that there we have, Madam Speaker, a situation where the country said, no, we need to legislate this. We got rid of the SIA and we allowed legislation to control surveillance. You get a judge's warrant. You know when? Only if there is a belief and a pursuit of criminal prosecution under Section 8. You go to a judge then, after you've been surveilling all along. And it is when you get that warrant, anything obtained thereafter can be used to criminally prosecute. But the other side of that story is this, and I want to repeat this. Nothing prevents any of the authorized officers to put surveillance on, and I do not want to bring the chair into it, but anyone in the society, on the basis of national security issues, on the basis of safeguarding the economic well-being of the state, or for the purpose of giving effect to certain agreements. Nothing prevents any of those officers from causing surveillance on members of the media. And that is a frightening thing, because when there is that danger, people are less likely to speak. Now we're in the era now where we're speaking about whistleblower legislation to open up communications so that people will feel freer to speak. That is how democracy thrives. When people are unafraid to speak, respectfully of course, and sometimes disrespectfully, but they're right to speak with each other, to not be, what shall I say, macoed on. Because you never know where that will end up. Let me give you a prime example of the dangers of this thing. As a former Minister of Justice, there was a very senior officer whom I had to sign off for confirmation for his position. But I got word from the Ministry of National Security, and I will not give sufficient detail because I will not breach that confidentiality, that there was a report on this man that he dealt in drugs. So I said, well, you know, I have a duty now. Is either I could confirm to the DPA or I could refuse. But I need to have a basis upon which I can make a decision. Well, I waited for weeks, which turned into months, and I insisted, I put a deadline and said, listen, if I don't have it within 7 days, I'm going to proceed. The report came. Undated, unnamed, no location given, an allegation that the man was seen passing drugs to somebody. Pure vapor. Now, if that is the intelligence that we use in the society, then anyone can be destroyed career-wise. Or in other things, shop talk, rum shop talk. And that is why when I spoke about intelligence, really is not intelligence. And there it was, a very senior officer whose career could have been limited, and he had no idea, you know. And the point made by the member for Siparia as to whether, you know, this database or some of the allegations made against you is real in the society. And that is one prime live example of the dangers of surveillance without going further. There are reports in national security. And you'll be embarrassed when you poke into it to see the merits of these things. There's a businessman who has lost his right to travel because of a report of an intelligence investigation that suggested he was involved in something less than acceptable, without any reference to evidence. And there you go. This is the power we'd be giving now to a director.
The political control.
That is the point, sir. You see, I am not making any allegation to the good gentleman for point 4. We're making law for the future. Noble men who hold office today, like the Attorney General, knowing you for all the years, I do not expect for a moment you will consider doing anything to injure our constitutional rights. But we don't know what the future holds. We do not know who will sit in the seat as Minister of National Security in the future. And that is why we have today the opportunity, because we have a commitment from all sides, to let's do it right and protect the citizens, to protect even the institutions. And I will come to that in a while. But that is crucially important. Because I want to say this. January 7th, the nation awoke to hear of a Colonel Robinson now heading the SSA. How many knew of him? Maybe some did, but most did not. We had no idea. We were told that Cabinet did its due diligence and decided that Mr. Robinson should be its director. But, and the devil is always in the details. You see, here much, and it's important to deal with some of that. It was not good then, and it is not good today, but because it was limited in its scope in relation to transnational drug trafficking issues of that nature, maybe, as they say, you give it a blight. It was wrong then, but it becomes deadly dangerous now because of the far greater scope of authority. And look at the kind of offenses now that this SSA will be able to look into. But just as we begin looking at the Strategic Services Agencies Act of 1995, 3.1, the Strategic Services Agencies hereby established, consisting of the director and employees of the agency. But this is the sting that we cannot allow in a modern parliament. The functions of the agency shall be exercised by the director after consultation with the minister. What does that mean? After consultation.
Not necessarily.
Not reporting to him, but that the functions of the agency shall be exercised by the director after consultation. Politicians, indirect control of a state agency that has investigative and therefore down the line prosecutorial powers. It pains me to be reminded and to remind you that we have a long history of political interference on the landscape of our political history. It was not too long ago, and even if for some it was a long time ago, the sting is still as painful to know that a former prime minister was prosecuted and that the highest courts had to find that there was bias in that prosecution that involved the chief magistrate and a sitting attorney general. It is not for me to judge what happened then, or for us to reinvent or to re-litigate. That was a finding of our court. That is another case of the Chief Justice being prosecuted. Oh, I thought the 70-year-old was the Chief Justice. I'm sorry. Yes. There were two separate. You see, it is replete with examples. A Chief Justice on a Friday evening at his home outside of it, of course, Hi. Machine gun toting police officers and others, several carloads of them, outside a sitting Chief Justice's home in Trinidad and Tobago, our beloved nation, our democracy that we talk about.
Head of the judiciary.
Head of the judiciary? To be taken away like a common criminal, and if he did wrong, of course. But you see, these are the things we must not forget. And what happened ultimately with the case? And that is why this is so crucially important that we get it right now. Not wait to have tombstone legislation if it happens again and then come back and say we should have fixed it.
I like that phrase.
It's tombstone because some people do die in the process. If not physically, their character and their reputations are ruined by prosecutions, which we call political prosecutions, that we've seen too often in the past and we hope never to see into the future. And that is why, forgive me, we cannot support this legislation as is. I have made public statements of my intent always to support what is right for this nation, but equally, it is my bounden duty, like every one of us, on both sides actually, to do what is right for this nation's future, devoid of political interference in that serious aspect of law enforcement. You see, we're not dealing with the Commissioner of Police here, you know. We're not dealing with the Chief of Defense. We are dealing with the Director of the SSA, who, take away all the pretty talk, is handpicked. Handpicked. You see, as my friend from Point Fortin spoke about the qualifications of the good Mr. Robinson. Now, I have met him, but I don't know him. And I want to cast no aspersion whatsoever. But in the modern age, I have been bombarded, if I may put it like that, forgive the military term, of suggestions that his qualification is nowhere what? Remember, I do not know. I don't know. I mean, some are even suggesting the name Robinson is located within a member of the cabinet. I don't know. And it's not for me to spread these things, but the point that I'm making is that it's easy in a country like this for allegations and insinuations to be made and could destroy even the good Mr. Robinson because he has not been properly brought before the people for them to say that this transparent approach to his election is what we approve. Who was the last director? Who was the last director of the SSA? You wish to speak, sir?
Amnesia.
Yeah, I have no amnesia. I remember these things. But what I do tell you is that we must always learn from the errors of the past. It is a fool's paradise to believe that you get experience only to look in your rearview mirror to see it. Your experience tells you that when you look forward, you will know what the circumstances are, what factual situations arise, so that you will anticipate predictability, Mr. Member for Point Fortin, as you speak to. Predictability. So if you know from the past this has happened, expect it to happen into the future and deal with it. You see, this thing may have been good 21 years ago, but it is not good today. This selection process. Because to read section 4.1, the Director General shall be appointed by the President for a term not exceeding 5 years, terminable at any time. So that if this person, this director, male or female, should fall foul of the Minister of National Security, or his Prime Minister, or any severely influential member of the cabinet, that person could be dispensed with because there is no basis, no criteria for his removal. And therefore, when we talk about tenure for judges and tenure for Commissioner of Police, this is really at the whim and fancy of the political directorate.
Dismissal at pleasure.
In this modern day and age, can we afford, without international embarrassment, to go forward on something like this? We cannot. But you know, it gets a little, if that was the tip and the end of the iceberg, that would have been bad enough. When we read on, if it was not certain under section 3.2 that the functions of the agency shall be exercised by the director after consultation with the minister, what does section 4, subsection 5 say? The director shall be subject to the directions of the minister. This couldn't be more black and white. As one of my former colleagues used to say, this is in written writing. The directions in this era of a person who holds such power, such authority. And listen what goes further now, to add more salt to the wound to our constitution. Yes, it was law, it is law till today until it is changed. The agency may employ staff as it considers necessary. What criteria? We hear now about relatives being had in MPs' offices. What prohibition is there for the or qualification requirements, or is this left entirely up to the discretion of the director and a select few others? Provide for the remuneration and other terms and conditions of the employment. Exercise disciplinary control over or terminate the appointment of persons employed. I wonder if this really, I mean, because we had it, but we never really examined it. But standing here as a lawyer, also, I'm embarrassed that this is the law, that the United Nations, of course, we know what happened, but we have brought change. You were elected on September 7th. You promised good governance. The people believed you and they voted you in. This cannot go forward. No. We as a people must deal with this. So, Madam Speaker, I was very heartened. Absolutely.
Is the member taking objection to the substantive legislation? You, as a former Minister of Legal Affairs in the government of Trinidad and Tobago, having lived with that for the last 5 years, you have a problem with it today?
Of course I do. And I have learned now that because there is change in the air, there are many things that were wrong in the past. And now that we are examining, if you were paying attention just a moment ago, I spoke to this issue, Madam Speaker, that we had not examined it, but looking at it today because we are about to change it. If we're going to change it, let's fix it. Because what this is akin to really is a change of use application to the town and country planning.
Good point.
Right? For a one-bedroom chapel in Centenary Extension in St. Augustine, put a 100-story luxury building without providing water, road. There is no foundation upon which you could build this thing there. The foundation upon which it is built is rotted. It is inappropriate. It is insubstantial and certainly out, the young people say, out of timing. We cannot go forward as a responsible parliament with these sorts of political control on a persecutorial arm at the end of it, of the state. And that is the point. You see, it is a Trojan horse. Because when, the personality of the Attorney General rises and speaks, you know, we believe, as we will, that as a man of honor and so, that he will not want to cause damage, as I've said before. But within it is that seed of rot. I know he did not intend it. In fact, when I was reflecting upon this, I thought it was really Pandora's box, and I do not wish to go through all of these things, but gift wrapped in such a pretty way, because the intent is noble. We all agree we need to get rid of the silos so that all law enforcement agencies could work together, come together, and have the intelligence, information, evidence, so that we can go to prosecutions, so that those who do wrong will pay the price. Ultimately, this is what we want. For too long, many who have done wrong have gone unattended, unknown, and certainly unprosecuted. And for those who have been prosecuted,
have expired. You're entitled to 15 more minutes.
I'll be most delighted, please.
You're granted.
Yes. Now, not that I was having as much fun, but I did not appreciate the time had flown. But to be reminded, as we were earlier today, that there is a judgment that emanated from the High Court of Trinidad and Tobago just this week, as reported in the newspaper, and until I see the actual judgment, I do not want to go much further into it. But it was most disturbing, if the reports are correct in the newspaper, there was an issue there of political direction for the prosecution of a senior police officer by one Harold Phillips, a senior police officer. So, what?
That's not in the paper. As the voice.
I shan't be troubled. I shan't be troubled by whether it was in the paper or not. I have said we shall wait for the judgment to read it. What I do know, one of the most respected newspapers in the country, The Guardian. The Guardian. Wednesday, March 16, 2016. And I know the judge, Frank Siparia, that's a very, the picture looks much like him. And the report says that the couple awarded $300,000 for a bogus charge. To be reminded, as they will try to drown out the truth a little bit, that we need now to ensure. You want to hit me in the face? You see, Madam Speaker, you want to hear a quotation? You know, I have listened to the Honorable Prime Minister as Prime Minister, and I'd listened to him when he was leader of the opposition and even before then. But I had a reason to reflect on what he said. As I know I have very limited time, I will have to curtail what I have to say. But I think his words, for those who do not know and do not wish to learn, they will do well to listen to what their Prime Minister said on November 19th as leader of the opposition then, 2010. And I quote, Hansard, "Thank you, Mr. Speaker. I was saying and advocating that we create proper institutions, that it cannot be that we will accept. What we will accept is something that when a government changes, what happens is that whoever was there is thrown out, and you pick your man or woman, and that person becomes the acceptance to the country, and until the next government comes in and throws that person out." Isn't that what happened? And we need now to insulate this person that we're going to give such power to from political manipulation, where they can be fired, hired, and expired. All that is going to happen is that in comes a new person, you pick your man or your woman and you do as you please until the next time. But on the other hand, if we are to learn from those who have gone ahead of us in this, and you have put proper structures in place, we too will then set out to put proper structures in place. But he said something even more. This is Hansard of your Prime Minister. Yes, you listen to this one now. And I really would recommend his statement to the Parliament on that date, because it really was uplifting to have heard him. But now we have the opportunity to do exactly what he preached to. So, Attorney General, I do not know if you shared with your Prime Minister the concerns that you must have seen about this thing about picking your own man. And then when a government changes, you get rid of that and you bring someone else in. There must be continuity in government. You've spoken about this. There must be structural build, institutional strength. And this is not what we are doing here. In fact, along the line, the leader of the opposition then spoke in words that if we continue like that, we would be creating an environment where, let me just read this, I could not put it better. The other one, this is at page 502 of the Hansard, dated 19th of November 2010. The other one in parallel is to protect citizens from abuse as the state proceeds to use that tool under the rubric of national security. If we accept that both have to exist, then you have to find out what kind of institution, laws, arrangements, and regulations are to be put in place to allow the state to function in an unfettered way, while at the same time not creating a modern-day Gestapo to be abused by office holders for their own nefarious needs. Yes. This is Dr. Keith Rowley. His words. You have the authority. You have the corporation on the side. Let us do what your Prime Minister said. Let us not repeat the errors of the past. Because the future, as I always say, must be better than yesterday. We cannot recreate the past, but we can create the future we want together. Thank you very much.
Member for Toco, Grande.
Thank you, Madam Speaker, and honorable members of this House. A fundamental requirement for any measure addressing criminality in this country must be strictly relative to the condition that this country now faces. Madam Speaker, in reply to my most honorable friend, St. Augustine, on the opposite side, I want to say how happy I am that he has recognized the opposition at the time, which was the PNM government opposition, and their genuine interest in supporting bills in favor of this country and the scourge against crime. But I want to also remind him, Madam Speaker, that when he speaks of intelligence as a police officer, intelligence is not just rumor. Intelligence is not just vapor. That is information. We call that information. And it is this very sentence brings me to a popular quote which I want to read out in this House this afternoon here. And the quote states, "Human ordeals thrive on ignorance. To understand the problem with clarity is already halfway towards solving it." Amartya Sen. Madam Speaker, I really wonder, listening to a member from St. Augustine, I got a sense of fear. I got a sense of fear coming from his voice. Fear of persecution. But I want to assure honorable member and members of the opposite side that this government is not one to hang people in the absence of evidence. Now, Madam Speaker, I heard the concerns, and let me assure you also about the employment practices. I too, just about a few years ago, I was a practicing police officer, and we had regular interventions with the SSA. And I often wondered why I never saw advertisements in the papers for jobs there. But I want to say that many people have recognized mistakes of the past, and in going forward, we on this side promise to have transparency to the highest degree. I want to assure, too, that we recognize that the Trinidad and Tobago Police remains the primary agency for law enforcement in Trinidad and Tobago and detection. Madam Speaker, all of us who sit in this very august chamber should have a fair idea that this country and our defense and law enforcement agencies in particular are currently engaged in a complex and challenging era of national security and public safety. It is an era where criminal activity including murders, organized crime, drug production, and trafficking, are more prevalent than ever before. And the violence and lawlessness it fuels poses a very real danger to our dream of peace and stability. But, Madam Speaker, this experience is not unique to Trinidad and Tobago. We are a part of the global environment. We also cannot escape the fact of our location, situated as we are, between producing countries and consuming countries, which make us not only a transshipment point of drugs and guns, but also a drop-off point as well. So, Madam Speaker, over the last 6 months, the government has undertaken a comprehensive review of law enforcement with the continuing objective of assuring the safety and security of this country and the well-being of everyone in Trinidad and Tobago is upheld. We recognize also, Madam Speaker, that it is our responsibility to provide a safe and secure environment for every person in Trinidad and Tobago and visitors alike. Madam Speaker, Trinidad and Tobago has for some time become a prime transshipment location, an excellent point for depositing and shipment of drugs to points in Europe and North America. All available information confirms that most of the drugs, along with the guns, are remaining in Trinidad and Tobago. These guns and drugs are central to the current street-level gang violence, as gangs fight for turfs and control over various drug markets. Madam Speaker, the Trinidad and Tobago Police Service, as I said before, is the primary agency for detection of offenses in Trinidad and Tobago. I want to praise the hardworking men and women, of which I was a part of for over 30 years. And this organization constitutes, Madam Speaker, the major cog in the wheel of our crime-fighting efforts. We as a government, we are proud of their efforts, and I take this opportunity to strengthen their resolve. But, Madam Speaker, a major barometer of law enforcement capacity and the performance in any society is the homicide detection rate. And I wish to draw some examples from statistics I obtained from the CAPA of Trinidad and Tobago Police Service. In 2010, Madam Speaker, when this government demitted office, we had a 23% detection rate. In 2015, when we came back into office, Madam Speaker, that rate had gone down to 16% detection rate for murders. And I will also refer to gang-related murders, which is even worse. As indicated by the Attorney General a while ago, it has gone to 3% detection rate. Madam Speaker, this is troubling and it is unacceptable. Madam Speaker, there also continues to be an upsurge in gang and drug-related violence as perpetrators of homicide are in some cases become the victims of reprisal. Madam Speaker, the rise of crime in the Caribbean has been characterized by the increased use of more powerful weapons, resulting in higher mortality levels. And a major factor contributing to the surge of gun-related criminality in the region is the trafficking of narcotics, which has facilitated the availability of firearms. Madam Speaker, not only murders, but please allow me the opportunity to provide this Honorable House with figures in the area of woundings and shootings for the period 2010 to 2015. Madam Speaker, in 2010, shootings, we had 119 shootings. 2015, it has gone to 100 shootings. With the offense of wounding, in 2010, we had reported offenses of 154 with the use of a firearm. By 2015, it had gone to 284. Madam Speaker, I also wish to refer to statistics provided by the Crime and Analysis Unit of the Trinidad and Tobago Police Service for firearms found and seized from the years 2010 to 2015. 2010, a total of 382 firearms were found. By 2015, 691 firearms found for the year. Madam Speaker, the government of Trinidad and Tobago has taken significant steps, such as this proposed SSA amendment bill, to strengthen our combined capacity to vigorously and relentlessly pursue the criminal proponents to these transnational crimes. When I spoke about firearms seized in Trinidad and Tobago, I want to bring this Honorable House to the facts at hand. Firearms seized from 2010 to 2015, a sharp rise of 691. The detection rate dropped to 3%, gang-related murders. Ordinary homicides, the detection rate dropped to 16%, Madam Speaker. Serious crimes had a remarkable drop also. But Madam Speaker, with all the drop in these offenses, homicides have been rising. Madam Speaker, 691 firearms seized. But yet still, Madam Speaker, we cannot make a dent on homicides. We cannot make a dent on gang-related murders. Something is amiss. Madam Speaker, it is clear, Madam Speaker, that the firearms and illegal drugs are the main reason behind our country's high crime rate. To stymie these types of crime and to bolster this country's detection rate, we need to be aware where the guns and drugs are coming from and who the main players are in this scenario. This can only be achieved through the proper intelligence sharing and information gathering mechanisms assessed at the strategic level before operations can play out on the ground. Having regard to the legislative mandate of the SSA and the current fragmented approach to treating with crime types, there exists a need for one strategic coordinating crime center for specialist national security functions, as well as to provide intelligence and analytical support for the appropriate operation and intelligent arms of the respective services indicated in the SSA Act. Madam Speaker, the SSA will, in essence, support and cooperate with law enforcement officers more vigorously and seek to boost this country's detection rate. Madam Speaker, intelligence-led policing focuses on key criminal activities. Once crime problems are identified and quantified through intelligence assessments, key criminals can be targeted for investigations and prosecutions more furiously, because the groups and individuals targeted will be those responsible for the crimes. Madam Speaker, while the criminal justice system as a whole provides some deterrent effect, a key question for policy development with regards whether enhanced sanctions or an enhanced possibility of being apprehended through an improved or enhanced detection rate provide an additional deterrent effect. So, Madam Speaker, what we need to look at is whether, if we provide our agencies with more intelligence, if it could enhance the detection rate to have an impact on drug-related activities, homicides, and gang-related murders. Madam Speaker, research has shown that all indicators point to the fact that an increased certainty of being caught will be more likely to produce more deterrent benefits to persons committing future crimes. And I think about what I just heard, Madam Speaker, from the persons opposite me, St. Augustine. There seemed to be a fear, and I felt happy with that, Because once we have that fear created in the minds of the people of this country, the whole idea of committing an offense, it deals with the deterrent effect of criminality. Madam Speaker. Madam Speaker, I am saying again, that is a deterrent effect in criminality. Madam Speaker, if a person knows he can commit an offense without being caught, would he do it? I ask the question to this Honorable House. If a person knows he can commit an offense without being caught, can he do it? Plain and simple deterrence predicts and posits that a person will not commit an offense if he knows he will be caught. Madam Speaker, this is basically the premise of a deterrent principle. I did not say this to bring fear to anybody's mind. Madam Speaker, the national security environment is dynamic, and it is clear that organized crime will continue to challenge us if we do not take a more strategic approach to crime fighting and national security. Organized criminals will continue to change their methods and structures to avoid detection. Our citizens' lives depend on us getting this right as a national security community. Now, more than ever before, the national security community needs to collaborate, share information, improve our methods of working together, and remain vigilant against all forms of threats. Madam Speaker, the 21st century has brought new challenges for the police in Trinidad and Tobago and the region as a whole. Madam Speaker, terrorism, globalization, large-scale population movements, transnational organized crime, and entrenched social problems pose crime control threats that are increasingly seen as beyond the scope and capability of traditional policing. To combat some of these challenges, many countries over the last decade have reviewed, studied, and slowly but steadily transformed their intelligence operations. Most efforts have focused on reorganizing and enhancing the intelligence infrastructures at the state level. Such enhancements make it possible for the state's law enforcement agencies to play an even more crucial role in securing the nation. But perhaps more important, improvements to intelligence operations help local law enforcement respond to traditional crimes more effectively. In the past, Madam Speaker, officers on the beat were an excellent resource and still is for gathering information on all kinds of potential threats and vulnerability. However, the intelligence operation of the state and local law enforcement agencies often are plagued by a lack of policy, procedures, and training for gathering and assessing essential information. To correct this problem, Madam Speaker, fundamental changes are needed in the way forward. In collaboration, collation, and analyzing of information into intelligence. Traditional intelligence functions need to be replaced with cooperative fluid structures that can collect information and more intelligence to end users more quickly. In this regard, the operations of the newly restructured SSA would enhance intelligence gathering and sharing and improve interagency coordination and operability. The newly restructured SSA would therefore engender a well-functioning single agency with a robust integrated nationwide system for coordination and the communication within the national security domain. So, Madam Speaker and honorable members of this House, we would recall that the Minister of National Security had indicated in November 2015 that there was a need to review the nation's security apparatus and that a number of adjustments needed to be made in strategy and in the structure of the security institutions themselves. Madam Speaker, the Ministry of National Security is now working towards introducing a reform agenda at the strategic level to address some of the current and emergent challenges we may face in the 21st century. In this regard, the Ministry of National Security has been developing strategies and concepts at the strategic level, which are appropriate for this new era, while rethinking and reviewing past approaches to the organization, training, and equipping of law enforcement operatives, as well as other human resource necessities. In providing an assessment of potential threats, the Ministry of National Security believes in doing things by beginning with the end in mind. This is being done so that a clear picture of the end is known by all, so that we can also clearly understand where we are going. In other words, we must take a clear and relevant policy strategy perspective. This is needed if we are to position this twin island republic where it can deal with its long-standing security challenges in a more effective and efficient way. The unacceptable levels of crime-related gun violence and antisocial behavior continue to pose a fundamental threat to the economic and social well-being of our people. And therefore, it is one of the highest priorities of the ministry. In addition, Madam Speaker, the ministry's policy is grounded on the philosophy of a whole-of-government approach. This approach will ensure that the policy, strategy, and objectives are nested in the national interest across all ministries. This will set out a strategic framework, Madam Speaker, and action plan designed to ensure that the government of Trinidad and Tobago can prepare for and respond to a range of security threats, including illegal trafficking, murder, trafficking of arms and ammunition, the formation of gangs, terrorist attacks, outbreaks of infectious disease, natural disasters, cybercrime, and domestic extremists. Madam Speaker, there is need for one strategic coordinating center that provides a specialist function with intelligence and analytic support to those national security agencies identified in this SSA bill. Madam Speaker, this is the strategic approach we must take at this crucial time in our crime-fighting efforts. So, Madam Speaker, I expect that the members opposite would recognize the importance of this legislation. Give your support to these amendments and assist us, as we did 5 years ago, in restoring the safety and freedom from fear of criminal elements in our beloved country, Trinidad and Tobago. Madam Speaker, this amended Strategic Services Bill of 2016, which this government of Trinidad and Tobago has brought to Parliament today, seeks to provide our law enforcement agency with a greater understanding and knowledge of the criminal structure that presently exists in Trinidad and Tobago. And Madam Speaker, I take this opportunity to urge our law-abiding citizens of Trinidad and Tobago to stay strong to your moral values. Stay strong to your moral and spiritual values. This government came into office with a belief and a promise to give transparency of government to the people of Trinidad and Tobago. And we will stand to our promise, Madam Speaker. This government will continue to do its part to maintaining and restoring the safety and security of our land. And I encourage members opposite to lend your hand, support this amended bill brought to this honorable house today as we continue our efforts in the war against crime. I thank you, Madam Speaker.
Member for Couva South.
Thank you very much, Madam Speaker, as I rise to join this debate, and I want to assure the Honorable Attorney General that I have not taken any bait from him in joining this debate. I have joined this debate because this is a very important piece of legislation that has been proposed by the government of Trinidad and Tobago as we continue to develop as a country and a society. But it is important too that as we develop as a country and a society, when laws or amendments are proposed, we must ensure first and foremost that the rights and the constitutionality of all our citizens are protected in any democratic society. And before I go on, I want to take the opportunity here this evening to congratulate two new super ministers which have been created by Prime Minister Dr. Keith Rowley in relation to the member for Lahakuta Talparo, who is now the Minister of Communications and the Minister of Public Administration, and the member for Port of Spain, North St. John's West, who is now Minister in the Ministry of the Attorney General and Legal Affairs and Minister in the Office of the Prime Minister. I wish you two super ministers all the best.
Stuart Little is Stuart Big. I thought that word was on there already.
Madam Speaker, I will not seek to pronounce on what was just said. Madam Speaker, as I listened attentively to the member for Toco and Grande, I was forced to do some sense of introspection because in her previous incarnation, the member for Toco and Grande was a former Assistant Commissioner of Police of Trinidad and Tobago. And instead of reeling out a number of statistics and so on, I thought that she would have come up with the prescription to move the police service and also the Strategic Security Agency in terms of addressing the very important issue of crime in Trinidad and Tobago. But I did not hear anything that will force me to respond to what she had to say. But also I listened during this debate here today, Madam Speaker, about pronouncements which are made by the Honorable Attorney General as it relates to the committed and dedicated citizens of Trinidad and Tobago who serve the respective law enforcement agencies of this country. And also the Minister of National Security, who indicated that the government needed a second opportunity to get it right. And if we are to get it right, Madam Speaker, we must indeed learn from the lessons of the past. And if I am to read into the records this evening, Madam Speaker, and I want to quote from a statement by the then Prime Minister of Trinidad and Tobago, the Honorable Kamla Persad-Bissessar, when she made a statement in this very said house on the interception of communications. And I read and I quote directly from this statement, Madam Speaker. And the then Prime Minister indicated there were reports as well about the possibility of financial irregularities as well. Reports from the police indicated that the SIA was a virtual law unto itself. It reported directly to the Minister of National Security and the Prime Minister. And there are serious concerns about accountability and transparency. Special branch officers found on that fateful day, when they went in on October the 23rd, 2010, in excess of $5.9 million in cash and an undisclosed quantity of firearms and ammunition was seized. Internal audit reports revealed that some $15 million cannot be accounted for to date. Madam Speaker, that is the kind of things that we must be prepared to guard against if the government wants the support of the opposition on these proposed amendments.
Come clean.
You all must come clean, and you must be prepared to dialogue with the opposition. You have consistently said, if I could recollect, during the first budget presentation of this government, the Minister of Finance said that, and he used the word consultation approximately 20 times throughout his budget speech. And we are approaching the midterm year review, and not one consultation has even been held on the state of the economy of Trinidad and Tobago. Madam Speaker, and if you want the government support on the issue of consultation as we move forward, you all want the opposition support. Madam Speaker, you must be prepared to understand that we have a legitimate role in this parliament, and we will not shirk our responsibilities. And that is why Mr. Reginald Dumas, former head of the public service, had to remind the government that let's do this together has failed miserably over the last 6 months. And you seem to be championing the pronouncements of Tobago West that we are in charge and we will do what we want, and we will ride roughshod over the civil liberties of the citizens of Trinidad and Tobago. Madam Speaker, I will not be distracted by the member from Aruga table, and he went to address a consultation and he did not know what he was there for. And on 3 occasions he told the consultation, he told the audience, I did not know what I was there for. So he has little to offer this parliament and the people of Trinidad and Tobago. So, Madam Speaker, as I said, and I want to read into the record also from the Newsday, Thursday the 10th of September 2015, sorry. Retired Brigadier General Edmund Dillon, a former Chief of Staff and new MP for Point Fortin, yesterday announced a review of the security architecture of Trinidad and Tobago, and, end of quote, and he indicated that he will not rule out the reintroduction of the disbanded Special Anti-Crime Unit of Trinidad and Tobago. So these proposed amendments seem to be the emergence of what we would call sort 2, Madam Speaker, and that is why we must be prepared to be very vigilant in terms of what unfolds in this Parliament here today. I say so, Madam Speaker, because we all know that in sort 1, if I should use that term, every sector of the society, whether it was the trade union movement, whether it was the media of Trinidad and Tobago, whether it was private citizens, their invasion, their privacy was invaded, and we are not told up till today. We are not told up till today from the Honorable Attorney General what safeguards are being put in place as it relates to safeguarding the privacy of the ordinary citizens of Trinidad and Tobago. And Madam Speaker, as I said, if we are to go forward, we must be prepared to learn from the mistakes of the past. And today we have heard from the Honorable Attorney General as he piloted the proposed amendment of the critical importance for the expansion of the Strategic Services Agency, and that this agency will now have a critical role in relation to not only surveillance and intelligence as it relates to drug trafficking and monitoring of drug trafficking and so on, but it will seek to take into consideration 67, if I stand to be corrected, 67 new areas of what we would call serious crimes. But what the Attorney General did not say to each and every one of us and to the wider citizens looking on and listening is, Madam Speaker, what kind, and I know that he may say that that is a national security issue, and that is for the consideration of the National Security Council of Trinidad and Tobago. But certainly, Madam Speaker, in an expanded role, we will want to know how much money will the government spend on surveillance equipment and techniques that they will pursue. Because certainly, Madam Speaker, we will not want to see blimps taking to the skies of Trinidad and Tobago again. And I want to read from, we have no problem in being transparent and accountable at Rienzi Complex in Couva. I can't say that for Balize House. But I want to read from an article written by Richard Sharon of the Express, Wednesday the 3rd of December 2008. Blimp back in action despite move by government to cut back on expenditure. Government fiscal restraint in the face of a global economic meltdown does not include pulling the state-owned surveillance airship out of the sky. The Skyship 600 is costing taxpayers more than $46,000 a day. The Skyship 600, now concealed in a hangar and behind a yellow tarpaulin at South Kumoto Base, is being operated and maintained at an annual cost of $17,010,000, a clear sense of wastage at a time in 2008 of what we would call a global economic meltdown. And what safeguards are there? What are we being told by the Honorable Attorney General this evening that this same kind of wastage will not go on in relation to this expanded strategic services agency, Madam Speaker. And Madam Speaker, I want to further indicate that this kind of wastage in times of little, based on what the Prime Minister alluded to recently in the public domain when he said Trinidad and Tobago was not bankrupt, but Trinidad and Tobago had a cash flow problem. We must be very responsible in terms of the amount of monies which will be allocated in terms of equipment that will be purchased by the government of Trinidad and Tobago as it proposes to expand, the security, strategic security agency. Madam Speaker, I also want to focus on the issue of the commitment or the homage that was paid by the member for Toco, Grande, and the Attorney General also, when they both spoke about recognizing the hard work of the dedicated officers of the respective law enforcement agencies in Trinidad and Tobago. And we have not been told, the leader of the opposition has called for it, in terms of the organizational structure of this expanded SSA. Up till now, the Attorney General has not indicated what is the current workforce or the manpower levels that exist currently at the SSA. And based on the expanded role of the SSA, what would be the manpower levels that would be required based on the new organizational structure? And in addition to that, how will they be compensated? Because, Madam Speaker, it is important that we address this very fundamental and critical issue of compensation, because in the last incarnation, the morale of officers who were in the police service of Trinidad and Tobago was at an all-time low when compared to the officers who were engaged in the SSA. And I say so because whilst they recognize and whilst they pay homage to the role of law enforcement officers within Trinidad and Tobago, the Minister of Finance up till today cannot advise the Parliament of Trinidad and Tobago and cannot advise the Trinidad and Tobago Police, Social and Welfare Division when will the outstanding back pay and the liabilities that are owed to workers, to officers based on the collective bargaining process, when will they be honored by the government of Trinidad and Tobago? And I also call upon the Minister of Finance and also the Attorney General of Trinidad and Tobago to tell the Parliament, to tell this Honorable House, when will law enforcement officers get their those who fell in the line of duty, such as the families of Police Constable Russell Ramnarang, who was killed on the 14th of December 2015, Police Constable Sherman Maynard, who was killed in the line of duty on the 24th of July 2015, and Sergeant Wendell Manwarin, who was killed in the line of duty on the 19th of February 2013. When will the government honor this commitment based on their pronouncements of recognizing the value and contribution of law enforcement officers to nation building. And Madam Speaker, I say so too, because in this new organizational structure, if based on intelligence gathering and based on the crime levels that we are currently witnessing in the country, if an officer attached to this expanded entity falls in the line of duty, is killed in the line of duty and so on, is there going to be some kind of compensation for the families of these, whoever falls in the line of duty, God forbid? That is something that we must hear also from the Attorney General of Trinidad and Tobago. And Madam Speaker, in keeping with the issue of protecting the rights of the individual and the civil liberties of the individual, we must ensure collectively, if the government wants the support of the opposition, that the SSA must be free, or intelligence gathering must be free of ill will, malice, vendettas, and political agendas. Because at the end of the day, Madam Speaker, I am very concerned based on an article that I read in the Newsday of Wednesday, the 16th of March, 2016, page 5, which was alluded to by my colleague, the member for St. Augustine. But I will just want to deepen the point that I am making here today when, and I am quoting directly, it was written by Jada Lautu, a High Court judge has admonished a senior police officer for his conduct in an investigation of which he was in charge of in 2003. The judge advised that the police service must always guard against actual or perceived political influence. And he went on in his ruling that was delivered. Justice Siparia found that then Assistant Superintendent of Police, now Deputy Commissioner of Police, Harold Phillip, maliciously prosecuted his colleague. Policing is serious business and requires impartiality and keen sense to do that which is just and right. Madam Speaker, I make this point because policing and intelligence gathering go hand in hand. And I want to further quote from the article to drive home this point, that the commitment to protect and serve shall always be undertaken in a fair, thorough, and comprehensive manner that is devoid of any political motive, direction, and/or ulterior motive. And Madam Speaker, if we go on to read this article, it is even more frightening in terms of what is stated based on the actions of this senior officer of the police service. The retired policeman alleged that Philip fabricated the evidence, unlawfully obtained statements by jurors from men who were involved in this investigation, failed to conduct sufficient investigations, and had no reliable evidence upon which to charge. And if intelligence gathering goes in the wrong direction, Madam Speaker, then I am forced to ask how or what is the right of recourse of ordinary citizens of Trinidad and Tobago. And this is what we must be prepared to guard against, because when a person's character is tarnished, when he or she is brought before the judicial system based on malicious and what we would call vindictive intelligence gathering, we are setting the seeds for a dictatorship. We are setting the seeds for a dictatorship if the political directorate is prepared to carry out such actions against its political opponents and so on. And this is very important as we continue to develop this debate, Madam Speaker. And also, as I address the question of the manpower requirements of this expanded SSA, I do not know if this expanded SSA is being done so that it could facilitate jobs for the boys. And we all know what was done in relation to the operations of the disbanded Special Anti-Crime Unit of Trinidad and Tobago. And today, this evening, Madam Speaker, I call upon the Attorney General to clear the air on whether they have earmarked that Nigel Clement, A1 Nigel Clement, has been earmarked for the position of the Deputy Director of this expanded Strategic Services Agency. That is very important, and whether other officers who are attached to this disbanded Special Anti-Crime Unit of Trinidad and Tobago have been promised re-employment in this expanded SSA. And that forces the question to be asked, what is the criteria? Where they will come from? Where they will come from? We have heard about secondment from the police service of Trinidad and Tobago. We would have heard from the public service. But where else will they come from? Customs? Prisons? Party group number 1, 2, and 3? We have competent people on the UNC executive. Mind your business. Mind your business. We are led by a political leader who has vision. We have an executive, we have a chairman who will take this party to be the next government of Trinidad and Tobago. So we have vision, we have capacity, we have a track record, and we will continue to be a viable opposition, an alternative government based on your dismal performance over the last 6 months. Madam Speaker, the Honorable Attorney General will not sidetrack me, and neither his sidekick, the Minister of Finance. So, Madam Speaker, you all will toss up on that side who is the boss and who is in charge and who runs the political party. That is no business of the United National Congress. So, Madam Speaker, as I said, the issue of whether it is job for the boys and whether we will see a return of persons, especially Mr. Nigel Clement, in his capacity, proposed to become the new Deputy Director, and whether persons, as I said, whom were in the former Special Anti-Crime Unit, will they return to this new or expanded entity. Madam Speaker, in addition to that, I want to take the opportunity to address the very important issue of the Trinidad and Tobago Police Service is governed by the operation of the Police Service Commission, and there are regulations and so on that guides the operation of the Trinidad and Tobago Police Service. But it is important to clarify that the SSA is more or less a civilian agency. And in that regard, Madam Speaker, the tenure of the persons who would...
Your 30-minute speaking time has expired. You're entitled to 15 more minutes if you intend to use it.
Yes, Madam Speaker, I will avail myself of my entitlement. So, as I was saying, I was indicating to you, Madam Speaker, that the issue of, or the existence of the persons who would be engaged in the expanded SSA, if they are seconded from the police service, or if they come from within customs or the prison services of Trinidad and Tobago, what will become of their years of service? What will become of their pension entitlements and so on? And as I said, Madam Speaker, how would the very important or pertinent issue of gratuity be addressed? And who would set their salaries? Whether it would be the office of the chief personnel officer, or will they be able to be represented by the recognized majority union from the place that they would have come from? Or, Madam Speaker, if, as I said, would they be allowed to engage in what I would call free and fair collective bargaining? This is very important to be clarified. And what will be the compensation levels? Who will set this compensation level, and what guarantee that there will be in terms of a disparity of salaries existing in the expanded SSA as against, for example, the salaries that are existing in the police service, prison, or customs, and so on. That is very important for clarification, and I think that in the interest of transparency and accountability and proper governance, that we are told of this before the end of this debate. Madam Speaker, you would have heard from the leader of the opposition. You would have heard from my other colleagues, and we have adopted a very responsible position, a position to Trinidad and Tobago, a position that we are prepared to ensure that we lend a hand of support to the government if they are prepared to send the proposed amendments to a joint select committee, if they are prepared to engage the opposition in meaningful dialogue, because the government of Trinidad and Tobago, whilst you may possess the political majority in this House, you have a responsibility to understand the relevant role and function of the opposition of this country. We will not shortchange the rights of the ordinary citizens of Trinidad and Tobago. We will not be associated with any kind of Gestapo entity. We will not support anything that will lend credibility to an unfolding dictatorship in this country. We will not support a government that is prepared to attack independent institutions such as the central bank. And I heard the member for Toco, Grande, indicate that we have nothing to fear on this side because the government will not hound anybody out of office. The DNA of the PNM is to hound persons out of office. Ask former Chief Justice Sat Sharma, ask former Governor of the Central Bank, Jawala Rambaran. Jawala Rambaran is out of the office of the governor, out of the office of the governor of the Central Bank, but the forex situation has not been resolved in Trinidad and Tobago. Madam Speaker, the Supermarkets Association have indicated the President that there will be a shortage of food on the supermarket shelves based on the fact that the exchange rate is appreciating and importers are having difficulty in accessing monies to import goods into the country, and that is why the President of the Supermarkets Association has indicated that there's an impending food crisis in Trinidad and Tobago. And in that regard, anything that is totalitarian or dictatorship or attacks independent institutions such as the Integrity Commission and so on, we will not be prepared to support. And that is why, whilst it is an important crime-fighting measure and so on, probably you all are looking down the road and you are seeing the signs of social instability on the horizon, and that is why you only after 6 months in office, while Trinidad and Tobago is in a state of paralysis, workers are feeling the brunt of the recession in this country. I thought that the Minister of Labor probably would have been here today to pilot legislation, amendments to the Retrenchment and Severance Benefit Act to protect workers and address the increase in mortgage rates and address the increase in retrenchments and so on. We would have heard these things. We are not hearing anything about socio-economic stability. We have been told by the Attorney General that he needs our support in relation to this piece of legislation. So I'm saying, if you are prepared to send this to a joint select committee, you are prepared to dialogue with the opposition in the context of the national interests of this country, in the context of the law enforcement officers and agencies of this country, we are prepared to give that meaningful support. Madam Speaker, I thank you.
Leader of the House.
Madam Speaker, by agreement with the opposition, I beg to move that this House do now adjourn to Friday, the 1st of April, 2016 at 1:30 p.m., at which time we will continue and conclude debate on this bill. And if we have time, we will do the local government motion.
Honorable members, before I put the question of the adjournment to the House, as members are quite aware, Trinidad and Tobago will be celebrating both Spiritual Baptist Liberation Day and Easter in the upcoming weeks. And I now call upon members to express greetings. First on Shouter Baptist Liberation Day, and I call upon the member for Moruga Tableland.
Yeah, pay attention.
Madam Speaker, good evening. Good evening, members of this House on both sides. It is with great pleasure and a sense of gravity that I stand to bring greetings to the spiritual Baptist community and by extension the larger community of Trinidad and Tobago on the impending celebration of Shouter Baptist, Spiritual Baptist Liberation Day. I do so for a number of reasons, one of them being that as my very good friend, the Honourable Member for Caroni East, has mentioned, I am by profession an academic historian, and full disclosure, I have presented papers and written studies, aside from economics, on the evolution of this religion in Trinidad and Tobago. But I also do this because I am born and bred a resident of Moruga, which is the de facto mecca of the spiritual Baptist faith. Madam Speaker, there remains some academic debate as to the origin of the Shouter Spiritual Baptist faith in Trinidad. There are views that there have been infusions from other Caribbean islands, for example, St. Vincent. But there is widespread academic consensus that the origin of this faith has to do with the arrival of the so-called company villages in Trinidad in 1816. In fact, they brought with them the entire Baptist faith. Contrary to popular knowledge, the Baptist faith is a very multifaceted religion. What later becomes known as the Spiritual Baptist or Shouter Baptist faith is merely one offshoot of a larger Christian faith. They would have been considered historically unorthodox, because their religion was infused with what would have been called, what can be typified now as Afrocentric traditions, or as some will call them now, New World African traditions. So they've developed a Christian faith that was infused with aspects that other Christian sects did not consider to be Christian. They were also differentiated by the fact that they, in the early days when they were called Wayside and Candle Baptists, they preferred to do their administrations, for example, on the side of the road, as opposed to constructing what were called campgrounds or early rudimentary churches. In the mid-19th century, we had a London Missionary Society came to Trinidad, and they had an intervention with the Baptist faith in Moruga. And that created a split which set the Shouter Baptists and Spiritual Baptists on a different path, in that the London Baptists were apoplectic about the fact that these people had the audacity to infuse their religion with these African customs, and they sought to purge those traditions from the faith. The Spiritual Baptists, or in the earlier incarnation back then, refused the administration and they diverged on their own path. Of course, that apathy to these traditions would lead the colonial government after some time to pass a Prohibition Act against this, what was considered a very devious faith. One knows, if one has any spiritual Baptist in your community, that the typical and traditional Baptist church is always found in subterfuge. It's always on a side street, never on the main road, always somewhere hidden, because of the fact that everyone knows that at one point this faith was considered illegal, and you could be arrested and prosecuted simply for attempting to celebrate as a Shouter and Spiritual Baptist. I'm saying all this not just to give a history lecture, but to give you a context, a larger context, which is that we ought to celebrate, we ought to venerate the Spiritual Baptists in this nation, because they struggled for a right that today we take for granted. Their fight, and I would typify it this way, was part of a larger fight towards real emancipation, where we have a society that under colonial rule was not free, where the majority of the citizens were never given the freedoms that we as Trinidadians and Tobagonians take for granted today. And they were not given. They got blows, they got arrested, they were brought before the courts simply for wanting the right that we all share today to worship whatever God we see in whatever way we want. Eventually that fight comes to fruition and they are granted the repeal of that act, and today the Spiritual Baptists, like all other faiths, have a constitutional right in this nation to worship their God as they see fit, and that should be celebrated. because it says that despite the fact that Trinidad and Tobago may have a number of problems today, we have been a progressive society that has steadily moved from colonial domination to creating an egalitarian society. And that is something that as a nation we should be proud of. So I take this chance as a person from Moruga, as a person who has some history and has had some immersion in the spiritual Baptist faith, to bring greetings to that community, to, on behalf of the government, wish the spiritual Baptists of this nation and to wish the larger nation of Trinidad and Tobago a happy spiritual Baptist Shout Day next week. Thank you, Madam Speaker.
Member for Naparima.
Madam Speaker, we on this side join with the national community in general and the members of the Shouta Baptist faith in particular in celebrating Shouta Baptist Day. Madam Speaker, it will be recalled that between 1917 and 1951, the spiritual and Shouta Baptist faith and its practices were banned by the then colonial government. The legislation which they enacted was the infamous Shouta Baptist Prohibition Ordinance, which came into effect on the 16th of November, 1917. This law banned and made illegal such essential Shouta Baptist practices as loud singing, indigenous music, bell ringing, the deeply introspective and soul-enriching practice of mourning, and animated worship. These were deemed by the then validating elites and the state as heathen, barbaric, and entirely inconsistent with a colony and a society aspiring to modernity, civilized behavior, and social and cultural development. Shouta Baptists were for decades subject to incarceration, fines, and humiliation if found practicing their faith. Madam Speaker, I recall my grandmother, her name was Bowie, speaking to her grandchildren with manifest trepidation about the horrors she and her fellow worshippers suffered in Fifth Company Moruga with her beloved Pastor Dixon, who I'm sure my colleague from Moruga Tableland will be aware of. And they suffered at the hands of the police during that unfortunate period. Madam Speaker, history will recall that it was a UNC government, an enlightened and progressive UNC government, which in 1996 saw it fit and did all that was necessary to make the 30th of March a national holiday. That date is important since it marked and celebrated the fact that it was the 30th of March 1951 that the Shouters Prohibition Ordinance was repealed. Madam Speaker, it will be further noted that it was a UNC government which took the required steps to ensure that the Shouta Baptists enjoyed all the rights and privileges of denominational bodies in the educational system of the country through the establishment of the St. Barbara's Shouta Baptist School in Maloney. The Shouta Baptists represent a truly indigenous religious institution with roots in Africa. It speaks also to the survival of cultural practices despite decades of state-sponsored oppression. It tells us that truth and righteousness will ultimately prevail. It is a tangible manifestation of the essential spirituality of a people who, through faith, inner strength, belief in righteousness of their convictions, can provide us with many lessons as we face these challenging times. We on this side will continue to support the philosophy, principles, practices, and institutions of the Shouta Baptist community as it seeks to be a full partner in every aspect of the growth and development of our country. We wish them every success in their future endeavors. May their struggle and successes be an inspiration to all of us. I thank you.
Honorable members, I join with the member for Moruga Tableland and the member for Naparima in extending greetings to the spiritual Shouta Baptist community on the commemoration of Spiritual Shouter Baptist Liberation Day on the 30th of March. The injustices suffered by members of that faith are well documented. And I wish to say and thank both members for how well they addressed the historical sufferings and experiences of that community. But I want to say that our nation has come a long way since then in valuing and recognizing our citizens of that faith and ensuring that they too enjoy the right and freedom for spiritual expression, religious expression, as stated in our Constitution, and in a true demonstration of the words of our national anthem, here every creed and race finds an equal place. The survival of that faith typifies values such as strength, resilience, and perseverance, values which will do us all well as citizens as incorporating into our individual lives. I therefore take this opportunity to wish the members of the Spiritual and Shouter Baptist community and to the members of the nation a day of praise, rejoicing, and thanksgiving. I now call upon the leader of the House to bring greetings to the Christian community on Easter.
Thank you, Madam President. Easter is the celebration of Christ's resurrection from the dead and is a foundation of the Christian faith. It is the oldest Christian holiday and the most important day of the church year. All of the Christian feasts and the entire liturgical year of worship are arranged around Easter. Easter is preceded by the season of Lent, which is a 40-day period of fasting and repentance, culminating in Holy Week, and followed by a 50-day Easter season that stretches from Easter to Pentecost. It is celebrated on Sunday, which falls on the 27th of March in 2016, and marks the end of Holy Week and the end of Lent. Easter Sunday is the last day of the Easter Triduum and the beginning of the Easter season of the liturgical year. For those who may not be entirely familiar with the Triduum, it starts with the Mass of the Lord's Supper on the evening of Holy Thursday, continuing through Good Friday service and Holy Saturday, and concluding with Vespers, also known as evening prayers, on Easter Sunday. The Triduum thus marks the most significant event of Holy Week. Christians believe that the resurrection marks the triumph of good over evil, sin and death. It is the singular event which Christians believe proves that those who trust in God and accept Christ will be raised from the dead. Since Easter represents the fulfillment of God's promises to mankind, it is the most important holiday on the Christian calendar. Accordingly, on behalf of the government and the People's National Movement, and on my own behalf as a practicing Catholic, I wish to bring greetings to the Christian community on this most auspicious occasion and to wish all of us a happy, peaceful, and holy Easter.
The member for point of prayer.
Thank you, Madam Speaker. Madam Speaker, it is indeed a pleasure to rise and offer Easter greetings to the national public and more specifically members of the Christian community, as well as you, my fellow parliamentarian colleagues, on behalf of the opposition members of Parliament. Madam Speaker, Easter is a celebration of Christ's resurrection from the dead. As the Member of Parliament for Diego Martin North East said, Easter will be celebrated on Sunday, March the 27th. And I agree, he talked about the Triduum and the liturgical year. As we all know from the Gospels, Jesus Christ rose from the dead on the third day, following his crucifixion, which will be on Sunday. Madam Speaker, as Frank Getty said, the message of Easter cannot be written in the past tense. It is a message for today and for the days to come. It is God's message which we must re-echo throughout our lives. Easter must not only be an inspirational period for the Christians, but for us as a nation. Easter shows or teaches the Christian community that God sent his Son to spread his blessed world and save them from damnation. Easter to Christians creates a time for reflection and resurrection. Many Christians at this time choose to renew their baptismal rites symbolic to Christ's resurrection. Similarly, we as a nation must use this time to reflect on how we can each better human beings. We must use this time to reflect as a nation on how we can be able to better the lives of each other. We must use this time and the theme of resurrection in our lives to know despite the challenges we each face, we can overcome. Today, so many of our nation's youth are following the wrong path. So many young people lack guidance and sometimes feel as if none cares. Easter should inspire us as adults to assist them to change their lives. We as leaders can and should represent the resurrection for these young people by ensuring they reach their full potential. As our nation enjoys this long sacred holiday, I urge families to spend time bonding with each other. Let us use this time to recreate the family unit. Madam Speaker, may we use this time to become stronger as a nation by being kinder as a people. To my Christian brothers and sisters, I ask you to strengthen your faith during this period, to be able to change the lives of the less fortunate and those in need of a tender hand. To the national community and to you, my fellow colleagues, may you have the gladness of Easter, which is hope, the promise of Easter, which is peace, the spirit of Easter, which is love. I thank you.
Honorable members, I join with the member for Digo-Martin Northeast and the member for Point of Vale in extending Easter greetings to the national community. Easter, as they've both said, represents the commemoration of death and the resurrection of Jesus Christ. It is the most important feast in the liturgical year of the Christian faith. The 40 days which precedes Easter is a time of deep introspection. Easter is a message relevant for today. It is a message of hope. It is a message of renewal. I therefore would like to suggest that all of us, as members of the national community, should endeavor to adopt the message of inclusiveness, compassion, and unconditional love displayed by Jesus Christ. Let his sacrifice be a lesson to us all, a reason of hope, a reason for light. I urge you all to use this time to forge stronger bonds with your families and communities and continue to pray for each other and for our country. To all members of this honorable house and to the people of Trinidad and Tobago, I wish you a safe, happy, and holy Easter. May the love and hope of the risen Christ be with you all. Honorable members, the question is that this House now adjourned to Friday, the 1st of April, 2016 at 1:30 p.m. All in favor, say aye. Aye. Any against? I guess the ayes have it. This House is now adjourned to Friday, the 1st of April, 2016 at 1:30 p.m.